Well, item number 9.
9.
It was heard by court number 17 on 3rd of October. In fact, I had completed my argument. And if your lordship will see third order of 3rd of October, it is written for further consideration.
Okay. Mr. L.K. Mishra, my senior counsel for the petitioner. And Mr. P. Nayak,
Lordship, GMD,
learned
GMD, Lordship.
standing counsel GMD, have submitted that the repetition has been extensively heard
I have in fact completed my argument. That's it.
by a coordinate bench of this court, by coordinate bench, within bracket, Mr. Devassis Purva J. on 3/10/2023. And case is to be listed. A case is posted today for further consideration. In such view of the matter, counsel for the parties have submitted. Matter will be listed before the coordinate bench to stop. The office, the registry, is to verify and list the case appropriately before the appropriate bench.
Yeah.
Lord, I'm praying for listing matter for withdrawal.
Tomorrow,
Yes. Public.
May I please, Lordship?
May I please, Your Lordship? Well, I have filed a motion matter on 10, my lord. So let them come for tomorrow, my lord. Motion, my lord.
subject matter,
And regarding settlement of market, my lord. Private market has been settled by the Panchayat Authority, my lord, in violation of division bench judgment, my
Monday,
lord.
Monday,
Cannot tomorrow, my lord.
Monday.
My lord, I prepare for listing, my lord. Filed on 27/9, my lord. Kindly tomorrow, my lord.
27/9.
My lord. Kindly tomorrow, my lord.
What is the subject?
Subject, my lord, this, our village is included as a Adarsha village, my lord. And the fund is sanctioned for our village. However, it is transferred to another village.
If it is other civil rules, then bench 5. Bench 5.
May I please, Lordship? I beg to mention a matter for admission, dear Lordship. The matter has been heard. There is a stay granting in my favor also. There is stay granting. It's a disciplinary inquiry, Your Lordship, based on anonymous complaints. Your Lordship has heard the matter. So the other side have not yet filed an affidavit. If Your Lordship can.
Hardly 4 days left in the next week, Mr.
Any day,
Sharma. It will be difficult.
I understand, Your Lordship. It will just
For
be a direction.
disposal, it will be
Not for
difficult.
disposal, Your Lordship will only issue a direction for them to file an affidavit. That's the only relief I seek on the next day. So Your Lordship can fix the matter on any day, on the last day. In fact, if Your Lordship pleases at the last matter, that will also suffice.
Not last day. Not last day, Mr. Sharma.
Yes, any day, Your Lordship. The matter will not be heard. In fact, Your Lordship will give that.
17.
I'm grateful, Your Lordship. I'm grateful.
May it please your lordship, I am praying for listing a case of writ petition for admission on Monday, lordship. Lordship, there is some urgency in the matter pertaining to settlement of weekly market for 1 year. So lordship, can it be on Monday?
Notices are served or not?
Yes, lordship. And the records are also there.
Appropriate date.
Lordship, listing for admission, sorry, orders matter, Lordship. Orders matter, Lordship, for list.
Orders.
Lordship. Next week, Lordship.
What subject?
Lordship, I have a Lordship, Eastern Kasai unit, Lordship. Time and again, Lordship, the deputy commissioner said directing me to shift the Lordship, Eastern Kasai unit, Lordship.
Orders matter next week will be difficult. Make the application before the registry. They will see how many matters are listed. If it can be accommodated, they will accommodate.
May I please, your lordship? I beg to mention these writ petitions for admission. These are matters regarding Manrega. The matters will be listed,
NREGA,
the matters will be listed immediately after vacation.
after the vacation. NREGA, what a vacation. Other civil rules. Find out from the registry which roster. I don't think,
If I may please your lordship, I'm praying for listing a matter coming Tuesday. The matter is, we are respondent number 5 and we have completed the tender work and also our completion certificate has been issued. But due to the rate petition filed by the petitioner, we are unable to get our payment which has been withheld along with the discharge of the future projects. So if your lordship may kindly allow 17th of this month. The matter was listed on 29th of September, 27th of September, and it was asked to be listed after 2 weeks. So it is the time has come also, your lordship. So if on 17th, your lordship may allow the matter to be
make the
listed.
application before the registry.
Registering. Okay, much obliged.
This is not a such a urgent matter.
Much obliged.
May I please, your lordship? Lordship, I beg to mention item number 1. I have already informed the other side.
Okay.
There is some personal difficulty on the part of Mr. Ethnat conducting council.
Yes,
He is
ma'am.
out of station.
Mr. F. already. Planet. Council for the petitioner submitted that arguing council, Mr. S. not has some personal difficulty to argue the matter today. And to that effect, my mentioned memo has already been circulated yesterday. First up, as the first up, he has prayed for listing of the case after the ensuing long vacation on a date to fix on first up. It is submitted that consent has been obtained from the learned council for the other sides respondents for such adjournment. First up, in view of the praise law is the case after the ensuing on a date after the ensuing summer vacation to be fixed by the
Much.
office.
Item number 2.
From Newton,
I have made the list, my lord, combining the two documents, my lord, submitted by the petitioner and respondent, my lord.
Okay, very good. Okay.
Mr. Kaur will take up in the second half with there are two matters which are to be heard
At
from
11:30.
11:30.
At 2 minutes.
11:30, two matters are to be heard from 11:30.
At 2.
So I don't know how long it will go thereafter.
At 2 o'clock, minutes.
After that. Read again. 2, 4, 5, 6.
From 3 to 6.
Yes. You wait, Mr. Kaur, you wait.
Yeah, my lord, is the case, my lord.
Lordship, before my senior start, lordship, in my affidavit, we have stated that we have sought clarification from the deputy commissioner regarding his land valuation certificate is yet to be received. The lordship may kindly. No, we have filed, but we have stated that yet to be received from the deputy commissioner. So lordship may kindly fix the matter next week. I'll get the instruction that VC has given clarification on.
Yes, Mr. Wanda.
But the affidavit, whatever they have stated, my lord, is clearly stated they have, my lord, received all the documents and after that they have filed the affidavit.
No.
Affidavit they have filed on.
This is my affidavit, page 49, paragraph 6.
There are 4 petitions in which
In WP number
petition.
8323, my lord. 8323.
8323.
My lord.
8323.
Lordship.
835.
8323, sir. This Fakhruddin
This is what
Barbia.
ferry service.
My lord. It is
Hmm.
Fakhruddin Barbia, lordship, petitioner. Page 49, paragraph 6, my lord.
इसको ऐसा दूं? Is number 49.
What reports?
Lordship, the ferry service will be sent to the government after receiving the reportable land documents of the petitioner. After land documents of the petitioner, Fakhruddin Borme from the Deputy Commissioner Kathar.
There I have seen, what is the land document? What verification?
Someone has made a complaint against their land documents, so we have some
Actually,
instruction from the Deputy
So
Commissioner.
far, the petition number 835, that is filed by my lord Bakshi Datta, petitioner. Here they have filed the affidavit stating that my land document is all correct. my lord.
Hmm?
Where it is.
Maybe correct, my lord.
Correct.
Valuation, my lord. Valuation,
Not-
it is, has to come from the deputy commissioner to ascertain that.
But so far my land inquiry was there, that is saying that this is a correct land, my lord. In that affidavit by filed by the transport.
Land may be correct, but value may not be correct.
Value is-
Actually, what is the case?
Case is, my lord, as per the,
I have taken this petition 8323. Who is the petitioner
This is
here?
mine.
Fakhruddin Borhuya.
It is mine.
Ah,
Fakhruddin Borme.
he challenged the comparative statement, and comparative statement has already been,
in which case you have challenged?
he challenged. this item.
Okay. Let us find out what is there.
My lord, my contention was that basically two grounds, my
No,
lord.
1 minute, I don't know.
Yes, yes, my lord.
Start from the beginning.
Yes, yes, my lord.
How many ferry service?
My lord,
There is a tender notice, 18 July 2022.
my lord.
And these repetitions are related to which one?
There is a
12 and 14.
I'll just clarify, my lord. I'll either, my lord, I may be permitted to say, my lord. There is a two ferry guard. One is Rajnagar and one is, my lord. I got selected
Rajnagar, 1 minute, let me find out.
Rajnagar and Rani Ferry, my lord.
Huh?
Rajnagar and Rani Ferry.
Where is Rani Ferry?
Jatinga, sorry. my-
Jatinga.
Ah,
Yeah, sorry, my lord. Next. Then,
okay, these two ferry service,
My lord.
Rajnagar and Jatinga.
my lord,
Now,
I got selected. I was not being given, for which I filed the writ. petition.
now petitioners are Bachu Datta and Fakhruddin Borhuya.
My lord,
You represent Bachu Datta,
Bachu Datta.
Fakhruddin Borhuya. Okay. Now, both of you submitted bid for both the ferry service,
First selected.
both the ferry service.
Yes.
Okay. Then why you have preferred the three petitions?
Just tell me.
One by one.
First writ petition I filed, my lord, I got selected, I became eligible and comparative statement has been made, my notes have been made, but it was not given to me because of the complaint lodged by him. Then, my lord, I filed a writ petition. During pendency of the writ petition, my lord, another minute has been passed without giving me opportunity, that I challenge. That honorable court, my lord, coordinate bench passed the stay order saying that you file two different writ petitions. So accordingly, we have to file two different writ petitions in respect of two ferry services.
Okay. And Mr. Mohanto,
My
you
lord,
filed
I-
a petition?
Yes, I have challenged the, my lord, being selected by the respondent number 4 as a highest bidder, violating the provisions of the, my lord, NIT clause 7 as well as, my lord, tender condition 4, whereby it was stated that the tender document must be accompanied with the all land revenue clearance certificate and the land document. That was, my lord, in while the, my lord, the tender documents along with the only bidding value and the technical weights were, my lord, published, it was specifically mentioned that there was no such document was accompanied along with this, my lord, tender document filed by the, my lord, respondent number 4.
Let us
online.
see the first minute.
Yes, my lord.
That your lordship will
No,
see.
first,
in-
let us see, Mr. Mohanto, which is the tender condition.
Tender condition I am coming, my lord.
You are
Yes, my lord.
alleging that this Bachu Datta
Yes, yes, yes.
did not submit
This is
Lordship, take up my.
my lord, let me complete. Page
I am
number
just, in my hand, it is 8323.
18, yes, my lord. This is my case. Page number 28, my lord.
1 minute. Mr. Chaudhary. At 11:30, there is a prayer yesterday. So item number 11 and 12 would be taken up from 11:30 onwards. Because Learned Advocate General would be addressing, then Mr. K. N. Chaudhary, Mr. K.P. Pathak. It may take some time. So your case may not be taken up today, I don't know. Subject to Mr. Nath.
I don't think it is likely to be taken up before the.
Next week it is not possible.
That is, can we fix up a date? Immediately on reopening, so that.
MS, please take the view of Mr. Nath.
Nath.
D. Nath.
Immediately on reopening, if we can fix up a date and.
Yes, definitely. So that might take the whole day also.
I understand, my lord. In fact, my junior was telling me. I appreciate it.
Yesterday I fixed the matter, but at later point of time that came.
No problem.
And for that, Mr. Learned Advocate General is readjusting his schedule also.
I appreciate, I appreciate. So. That much of accommodation, my lord, we have to, my lord, because I expect similar accommodation in
Yes.
Itanagar.
I will inform.
Find out. Set it up.
My lord,
Page 30 is the detailed terms and conditions of NIT.
Yes, my lord. Kindly come to my lord, clause 4, my lord. Land documents,
Clause 7 or 4,
4 or 28 page one number.
page 28.
Eight.
Okay, periodic patta jamabandi. Land valuation certificate. NOC,
Yes, my lord. The 5,
non-encumbrance certificate. Land revenue clearance certificate.
this is my lord important, my lord.
This is important.
Yes, my lord. Land revenue clearance certificate. And
Up to date income tax return certificate.
yes, my lord.
Okay, whose bid amount is above 6 lakh.
Yes, my lord.
And financial soundness certificate.
Certificate.
Okay.
So, but
Then what happened in the minutes?
minutes, my lord, they are initially, my lord, they published, my lord, the entire, my lord, list of the, my lord, accepting tenders. My lord,
No.
with their bid value.
Annexer 3,
Yes, my lord.
that is minute dated 13/10/2022.
Yes, my lord. After publishing of the list of the candidate along with it, they are all documents.
Where is Jatinga?
Jatinga number, my lord, first one.
As per the conversion,
Page
four
number
bidders-
53, first one, my lord.
4 bidders participated. Jatinga have deposited their required amount, estimated value, name of the bidders. Abdul Rahman Majumdar. He is not contesting. Abdul Rahman,
No, my lord, he is the failed.
Bachu Datta, all
Yes,
documents
I'm the one.
submitted as per
And
9.
Fakhruddin Bobby.
Fakhruddin, you are Fakhruddin.
I am, my lord.
All documents. Tender committee decides to accept the tenders of Fakhruddin, so and so, so and so. So this is technical bid.
This is technical bit
Hmm.
where it is, my lord, stated, in spite of, my lord, not submitting that document, that the, my lord, Basu Datta has submitted all the documents, my lord. But practically, my lord, these two documents he did not, my lord,
Where
annex
is-
with the tender.
Now you file complaint or what?
Yes, I file a complaint and that on the basis of that.
Where is
complaint-
the statement
Yes, my
in
lord.
the repetition?
Yes, my lord. My lord, para 7, my lord, para 8,
Para 7,
yes, my lord.
meeting, 1 minute, para 6, let us see para 6. Tender committee meeting on the basis of candidate was prepared, published the same by the respondent publication, the comparative statement. It had gone through and found that both the various services in their papers of respondent number 4 accepted. In spite of lacking numbers of document in violation of so and so terms and conditions for the period as well as clause 4 of the online, those documents are apparently not showing submitted. This is online.
This is online, my lord.
Okay.
It also be
So,
accompanied with the
Online and
application, my lord.
as
We
per the
cannot submit
condition of
subsequent.
NIT, issued tender have to submit land revenue clearance certificate from the concerned Mauser in support of his land document. Along with the showing of the application did not submit the same. So, but the
Manoj,
accepted a tender. According to tender committee held and the president committee officer also placed. Where is that 2010-2022?
My lord,
Okay, this 2010-2022 published.
published, my lord. This is public.
It was published. That minutes was published.
This is published, my lord. The final,
Okay.
my lord, he is been declared as a, he is one, my lord, selected for the body. my
No,
lord,
he is also, his technical bid was accepted.
accepted. But in
Okay.
spite of the lacking of this document, my lord.
Then what did,
My-
what
I-
did you did?
my
What
lord,
did you do?
Then my final complaint before the, my lord, authority
Complaint.
concerned. And on the basis of that, my
Oh.
complaint,
1 minute, where is the government?
my complaint was annex of 5,
Annexer, page
page, my lord, 44.
44.
That was addressed to the minister, my lord.
44. Okay, then
That was forwarded to the, my lord, director.
regarding, okay, 46.
Yes, my lord, 45.
I would like to
45.
impose a complaint petition. Submitted by Vachu Datta for leasing Zatinga and the period. Verification report of Vachu Datta. Any comparative statement prepared anywhere?
That was, my lord, not with me, but with the.
Anywhere? Okay.
My lord, may kindly have a look my affidavit filed in the
Oh.
number 8023.
Revised.
My lord.
Yes.
For
Revised.
annexure 1, lordship may kindly have a look.
Yes, Mr. Borbuya, how do you improve your case from lacking land clearance certificate?
My lord, that I'm coming, my lord. Yeah, what happened, my lord? Lordship kindly take up my item number 5, my lord. That
Five.
picture will be clear.
WBC
5 is, my lord, number 1.
I'm sorry to interrupt, madam, but all parties have agreed on 7th one, if it is not.
seven. Okay. 7 লিখে দিব।
Item number 30.
13th. এই নাম কেটা রিপিট করে দিব। I should read Vishwakarma, MM Kotoki 1, DNAT, Sailovatarva, and DNAT. Result council
Interim has to. Interim.
7, interim.
Obliged.
Lordship kindly take up, my lord, item number 8, WBC 835, item number 5.
835.
Lordship. Lordship kindly take up, turn to page 31. These are the documents, my lord, we have submitted. And I have annexed also. Then
Where is the land clearance?
Lordship will see page 32,
30.
32, 33. Vernacular is the 33.
This is deposit.
Yes.
This is not clearance.
This is the clearance I paid up to date tax.
What is the condition? Let us see
Lordship
again.
kindly see, Lord,
Let us see again.
Lordship,
I
at page 26.
7. Last line. The tenderer have to
Submit the
I have also to submit land revenue clearance certificate from the concerned Mauser.
in his own name.
Not deposit receipt.
This is separate certificate issued, my lord.
Do you have the certificate
I have
Let him
my
show-
the next one. On the procedure.
anywhere?
No, I have not mentioned, my lord, but this is there. There is no any dispute on my.
No, my lord, he may not have also, my lord. You have Lordship,
I don't know. We don't go by
Lordship has-
speculation.
Lordship.
We
has-
go by the comparative state.
Yes, my lord.
And it-
Lordship, my lord, this second comparative statement made, my lord, behind the back of me. That is my
Which one?
case. The comparative statement which have been annexed, that is subsequent.
Show me that comparative statement. It is said that land revenue clearance certificate not submitted.
My lord,
So this does not go to, yes, this may indicate that you have paid revenue, land revenue. This is not a certificate.
my lord,
This is
otherwise,
Salan.
my lord, otherwise,
There
my
is a difference.
My lord, I'll just clarify the point, my lord. In the Barak Valley, there is no such provision for issuing separate certificate. If my learned friend can show that he has submitted separately land clearance certificate, then my lord, I have no case.
This is delaying the matter.
Lordship kindly peruse the original record.
Why I will go?
My lord, we have.
Why I will
Because my lord,
disbelieve?
no, my
Why I should disbelieve in a
Lordship,
read
that's-
court?
lordship.
We are not in appeal.
No, my lord, I'm not saying about the bill.
It is
also.
for you to show.
Lordship, I have shown my lord annexure that I have what document.
I have seen this page 32.
My lord, government has, directorate has filed the affidavit, response number 2.
Lordship,
Where-
kindly see page 31. What document I have submitted.
You have said,
I
you have said, now in support
is-
of that, this page 32 is the,
No, yes, my lord.
page
Page
32 is
these
what?
are the documents.
Salaner Pharam.
Yes, my lord. These are the documents.
Salaner Pharam. It
My
is, Salan cannot be equated with certificate.
My lord, in that case, he
Who
is
is-
also not, he has also
and-
not submitted.
It is not the case, comparative
My lord,
statement.
lordship has just,
Let us see the comparative statement.
my lord, comparative statement, my lord, that has been.
My lord, may kindly have a look my affidavit file in that.
I have seen.
853.
I have seen,
Six, my lord, page 52, running page,
page 52,
paragraph 6, my lord. We have
page
stated
50,
2, my lord, running page,
50, paragraph 6.
paragraph 6, page 52.
Reply to Kotamar. Aso. What reply this one?
No, your comparative statement, is there any doubt?
Lordship,
Page 53,
yes,
53, your affidavit, annexer, that comparative, revised comparative statement,
Yes. There is no, we have.
4 bidders,
Yes,
right?
my lord. And the Basudatta.
Let us see court fee stamp submitted,
my lord.
experience certificate, financial soundness certificate submitted. As per clause 1 of the clause, if he does not have experience, he has to submit financial certificate. Bachu Dutta has submitted. Then periodic Patta Jamabandi submitted. Land valuation certificate submitted, but there is some doubt, right?
Yes.
In his case.
Huh?
In his case, value is the lesser.
Value is, will examine that.
That's why, my lord,
Then NOC of co-pattadar, not applicable, okay? But Fakhruddin, not applicable. Land clearance certificate. In your case, it is not submitted,
According to-
not submitted.
Property submitted, but he is not.
Huh? Yes.
According
Not-
submitted.
For other 3, submitted.
my lord.
So it cannot be a case that Kasar Valley, Mozada does not issue land clearance certificate, land revenue clearance, land
My lord.
revenue clearance certificate.
my lord,
It cannot be that submission cannot stand.
my lord, if the record reveals, my lord, they have said,
Why record?
they have original record.
Is it your case in the writ petition?
My case is that, my lord, only my lord, behind the back of me, my lord, revised meetings have been minute.
There is no requirement. Where is the requirement?
My lord, the
Tender
first,
committee has that inherent power. If something is sought to be clarified by way of complaint, they can revisit the decision until it is published.
my lord,
So where is the
Already
requirement
published.
that every stage a bidder is to be heard in the decision-making process? Where is the law?
decision.
Where is
process, I am
the
not
law?
saying, my lord, I am not saying.
In the
First
tender,
meeting,
for tender finalization,
my lord,
suppose 100 bidders have,
No.
everybody is to be heard.
lord, I am not.
We
of
have
that,
to
my lord.
see whether the decision-making process is liable to be interfered with because the decision-making process has taken irrelevant factors. Mr. Nath, 7th, because there is another sit, case which is likely to start at 11:30. So it will be very difficult.
My lord will see one thing, my lord. The first minutes they have uploaded. They have said, I am successful. He made a complaint. Then it became, my lord, they said, no.
It
your
is you to show land clearance certificate. You have referred to the challan.
My lord, just give me 1 day time, my lord.
Oh,
My lord, one thing I want to clarify, one thing, my lord, from their affidavit.
and what about his doubt? Tell me.
His doubt, my lord.
You are pointing finger to him.
Him, my lord,
What is that?
my lord, affidavit filed by the government prima facie reveals, my lord.
Which 8323?
Yes, my lord.
Okay, let us see.
Lordship will see the affidavit filed by the government in
Okay,
para
we'll
6.
see, we'll see.
My lord, if lordship will go by the para 5, that will clear how his stand is pleading with his stand, my lord. Because
Okay,
he's saying
let
that
us read it. This is the affidavit for all the cases.
this is,
They have filed.
In
is-
which case you have
it is
filed?
835, my lord.
Lordship, in both the repetition, I have filed my.
No, there are 4.
In
One-
petition number
one-
8323, I have
Huh?
filed my lord.
One is, my lord.
8323,
I have filed and another lordship in
835.
835.
835.
835, we have replied also, my.
Okay, we'll see to that. Okay,
Kindly-
8353.
835,
Oh, 8323.
Other repetition.
Let us see the,
My lord.
The other repetition, my lord, they have only segregated the part.
8323.
My
Government affidavit. Let us see.
government affidavit para 6, my lord.
Why not from para 4?
Lordship. May I read, my lord?
Yes.
With regard to the statement made in para 6 of the writ petition, deponent states that the executive engineer ITW division Silchar has revised the comparative statement of Rajnagar and Jhatinga ferry service by letter dated so and so, wherein it has been reflected that the respondent number 4, the Bachu Datta, has not submitted land revenue clearance with his tender. In this regard, review meeting was held on 1/12/123 for finalization of the tender of Rajnagar Jhatinga ferry for 2. A copy of the said letter so and so. That the deponent backs to state that the mentioned that the 2 bidders, namely Bachu Datta and Khairul Islam Borbia, had lost complaint against the land documents of the petitioner. Petitioner means is the Fakhruddin. Complaint petition where the sent to the Deputy Commissioner Kachar for inquiring into the matter by letter dated so and so 3/1/23. Furthermore, a subsequent letter was issued to the Deputy Commissioner by letter dated so and so 21/23 to expedite the report to enable the finalization of the tender of the Rajnagar Jhatinga ferry service.
So what is the nature of the complaint?
Complaint, my lord, the value of the tender and value of the land has to be over the value of the tender.
Okay, we'll look into that.
Value is lesser.
Okay,
my lord.
we'll look into that. Then
Yes,
paragraph 6.
That the deponent begs to state that the tender committee of the directorate ITW has reviewed his earlier decision by minus dated so and so, who is decide to accept the tenders of Fakhruddin and Khairul Ahmed Barbhoya and to reject the tenders of the Bachu Datta and Abdul Rahman Majumdar. Furthermore, the tender committee has recommended the name of the petitioner Fakhruddin for the settlement of Jhatinga ferry service for remaining period of 22 to 24. The proposal for the settlement ferry service will be sent to the government after receiving report from the documents from the petitioner Fakhruddin from the Deputy Commissioner. That report has not come.
it is come, my lord.
1 minute. Can we be-
835. Let us look at it. It is 835. 835. In para number 6 of plus 1. Para number 5 of plus 1. 5/6 of plus 1.
Paragraph 8.
Then, my lord, with regard to the statement made in para 13 of the writ petition, deponent states that it is true that the deponent has requested the Deputy Commissioner Kachar to submit verification report of the land documents of Bachu Datta as per complaint petition of Fakhruddin Barbhoya. However, the report from the office of the Deputy Commissioner Kacha regarding the land documents in respect of Bachu Datta is no longer necessary as the bid was rejected by the tender committee minutes dated so and so.
So you're already out.
I challenged the minute, my
Huh?
subsequent minute I have challenged,
Document not submitted at least, and his case is doubtful.
my lord.
And subject to receipt or report, they will finalize.
My lord, that will do, my lord. Another,
But you are out.
my lord, I'll just clarify, my lord. I replied to now.
Okay, let us see the other affidavit, government affidavit.
Comment available.
Let us see the,
It is
in
835.
835.
835, my lord.
835, lordship will see.
If his complaint is regarding the land
One,
valuation, then
one minute,
annex-
I do not know. Let me read it so that I can understand.
Yes, lordship, by affidavit, lordship will.
Better to have the affidavit.
Yes.
Yes, my lord. Comment.
Many
affidavit-
submissions are made which are not in the affidavit.
Yes.
My lord, lordship will see the operative parts.
Parthopegu.
Yes, my lord. It is the respond number to file the affidavit, my lord. Parthopegu.
Parthopegu. Who is the petitioner here?
Here is myself, but myself. my lord.
Okay.
Lordship will see the.
Has hard copies of his land revenue clearance in the office of the which is tender. However,
Lordship will see operative part.
if you had submitted hard copy of land in the office of the which is tender, however.
There are 5 onwards, my lord. The dependent back to the rich petitioner had submitted the hard copies of the land revenue clearance certificate. Now again doubtful, my lord.
However,
In the office of the respondent with his standard, because I have been asked 2 ways, my lord.
had not submitted the land revenue clearance
Yes, my lord,
certificate.
I'm reading my deponent backs to the rich petitioner had submitted the hard copies of the land revenue clearance certificate in the office of the respondent number 3 with his standard. However, the rich petitioner had not submitted land revenue clearance certificate with the submission online. Tender as mandated in clause 25 of
Let us see the tender notice once again.
lordship.
Who is the requirement of submitting hard copy?
Yes, I'm coming, my lord. Lordship, kindly take up 835 at which I have annexed, my lord, all that.
Tender document.
There are 28 onwards.
There are
Page 28 onwards.
28. Which part?
That the tender have to submit the certificate in some periodic office and there are 7 onwards, my lord, within the district submission of the.
No, which clause
Yes,
exactly?
I'm coming, my lord. Tender committee from the deputy commissioner, so and so, subdivision commissioner, so and so. Concern the tender must submit update with the non-incumbent certificate land revenues periodic purpose, so and so. The tender have to also submit the land clearance certificate from the concerned Mojamodatar. If there is more Patadar NOC, then the tender must submit the document in support of his residential with his certificate.
Point number 20.
I have seen 24, 25. However, clause 25.
Acha, the tender must submit the hard copies of the tender documents which are uploaded in the portal to the office of the executive engineer Silchar. However, the tender will be finalized on the basis of the documents submitted online portal.
Now paragraph 5. Then paragraph, let us see paragraph. They have quoted 25.
Then, my lord, I
When
have,
tender committee rejected petition as he had not submitted.
the tender document review.
Beyond has been recommended for settlement of service or remaining period. Read petitioner had lodged a complaint on the land documents. Submitted the report. Submitted the report. Let us see the report. Submitted the report. They have gone further now, state. As annexer,
But it is annexer,
Roman 4,
it is a 835, my lord.
65.
With reference to subject, I have.
All document they have, my lord,
The
annex.
inquiry reports of the executive.
Cycle officer report,
Silchar circuit uploaded regarding the.
Then
documents
executive
of
engineer,
in Borvia below. It
district
received the
development
report of the
commissioner.
said
All reports are there.
Fakhruddin Barbia, late Harun Rashid Barbia, part number Uttarban has landed property to RS Pata number so and so. Vasaga measuring 2 bighas so and so as per the registered deed number so and so. Further the value.
Then what is the total value you have? What is the?
Yes, I have quoted my lord. My value, if the both the ferry services were,
Both included
I quoted my lord in one,
in one,
3,82,700,
3,82,700,
82,700, and another my lord, 3,44,700, 44,700.
add both two,
Both took my lord, then
4,
it will 0, 0,
7, 2,
4, 1, 6, 7, 8,
100. Like his land value is
yes, my lord.
100 rupees more.
Yes, my lord.
By 100 rupees, he has made the standard.
My complaint was that my lord.
Deputy Commissioner, why will doubt about that? Come
My-
to Annexer Roman 4. Is there anything to doubt?
My lord, the valuation are. to be-
Mr. Deputy Commissioner has signed this
Circle-
and sent it to the Director IWT.
And that too on the basis of the circle officer report, my lord.
On the basis of your complaint,
My lord.
the tender committee did not finalize it. Matter was forwarded to the
No.
Deputy Commissioner,
Yes,
and Deputy Commissioner made an inquiry and submitted a report. So what else is required, Mr.?
my lord, the first meeting, my lord, my name was there as a successful, my lord. How come they?
So then suppose the arrow which kills Bali also kills Sugri. Now here is a case that you lost the complaint, inquiry started. He lost the complaint, inquiry started against you. Is it not?
Yes, my-
Yes.
then my lord,
Both are on the same shooting. Inquiry started against both of you on the basis of complaints lodged
my lord,
by the other.
my lord will.
So you lost the complaint. They made the inquiry. It is correct.
My lord will.
He lost the complaint against you. They made the inquiry. That is wrong. What is this?
My lord will examine only one vital point here, my lord, whether this the submission of the document both online and offline. Offline, they have already admitted.
Online,
No, my lord.
clause
offline-
25.
Analyze.
If they have professed a norm,
That is
that
all.
they will profess and follow that norm.
That is all.
And if they have followed it,
My lord,
what wrong?
the languages like this, my lord, they have to submit online, then offline.
Language is
Analysis
clear.
will be
Clause
satisfied.
25, language is clear.
Lordship.
Finalize.
A
will be on the-
categorical stand of the state respondent that however, the tender will be finalized on the basis of the documents
Online portal.
submitted on the online portal.
That is
My
all.
lord,
Clear.
uh,
And
why-
that inquiry also got completed. What
my lord-
grievance you have
My
now?
lord, only one thing will have
We
to,
do not find out the value of land.
my lord,
It
only,
is a deputy commissioner who is the last authority.
my lord will see, my lord, the similar circumstances, my lord, where the offline and online is allowed. Whether this is mandatory or not, my lord, that is or directory.
When the central coalfield, when the tendering authority says that it is essential terms of the condition, judicial review is not permissible.
My lord will see, my lord, then my lord, what is the?
If they have followed the process, where they have deviated? Where they have deviated?
My lord, first my lord says it is, I am having all the document. Now they are saying.
Yes, now you lodged the complaint, he lodged the complaint.
That is true, my lord.
And
Housing Company.
tendering authority, if they had done something wrong, palpably
My lord,
in appreciating the documents, they can revisit until it is finalized.
my lord will see first.
Finalization is when the LOI, LOA,
At least my highest bidder. my lord. So far.
that will not do.
Money will-
Highest bidder cannot insist.
No, my lord. Lordship,
it's,
lordship has to examine, my lord, whether this is mandatory or directory or any decision authority of law. Lordship, give me only one day, my.
Not required. I can give you 2, 3, 4. Central court is zero. I'll right now I am giving you. Central
My lord, I
Court
have to
also-
go through, my lord, at least a day, my lord.
No, there is nothing required. Yes.
And our High Court also says the same thing, my lord. In Abdul Mujib case, nothing can be improved in later stage, my lord.
My lord, I have not.
Okay,
included,
we'll
my lord.
start the dictation up to 11:30, thereafter we'll start.
Lordship will see, my lord, my affidavit reply, my lord.
I am giving you judgment instead of giving
Yes, my lord.
me judgment. I am giving you judgment.
I like to draw lordship's attention, my lord. I have categorically.
There is nothing, mister.
I have categorically denied, my lord. I have submitted. my-
Denial will not do.
That's why I'm.
It is your challan only. You have annexed in support of your claim about land revenue. Now, land revenue clearance certificate, you made a submission
My
that
lord, lordship
in
will
Kacha,
examine, my
Parag
lord,
Valley,
whether they are.
there is no system of issuing land clearance certificate.
Other persons have submitted or not, my lord. At least government can apprise. your lord.
No. We do not go on sitting in appeal everywhere.
My lord, only for.
We
the-
believe prima facie if something
My
is
lord,
not
this
mala
is
fide.
being taken into account as a-
If it is something is not mala fide, price is not the only criteria.
their affidavit, they said I submitted the offline also.
Offline,
Offline,
not
I-
online.
Online.
So
same
clause
document-
25.
Same document has been treated as a clearance certificate.
Show me land clearance certificate. The other three,
My lord, my
Parag Valley system is not there.
submission, respectful submission is that, my lord, whether they have submitted any one of them, my lord, apart from this.
We are not going, we do not.
Because,
go-
my lord,
We, not in every case we go.
my lord,
to
government has said, my lord, I have submitted the clearance certificate. Post, what is that about?
A result of this discussion is that the issue of the acceptance or rejection of a bid or a bidder should be looked at not only from the point of view of the unsuccessful party, but also from the point of view of the employer. Terms of NIT cannot be ignored as being redundant. Therefore, whether a term of the NIT is essential or not is a decision taken by the employer, which should be respected. What is the first repetition in point of time?
First writ petition I filed, my lord, being successful bidder, I have not been.
8322. 8323.
305 is the first.
305. No, 8323 is the first.
My lord.
8322.
2022 repetition.
Yes, my lord.
His case, my lord, he challenged, my lord, comparative statement. The case became infectious. After
Ah,
comparative, my lord, finality has been attained. The case became infectious, my lord. It did not come for amendment of the petition.
What?
In the 2022 writ petition, we only.
They have said in their statement itself,
The affidavit.
affidavit.
My lord, lordship will see their prayer, my lord, what they wanted. What they wanted in their prayer, my lord.
I'm setting aside his settlement, my lord.
Not settlement, my lord, comparative statement only.
He's giving settle, that was challenged in that petition.
He said, my lord.
Yes, that matter proceeded further. You filed 3 petitions.
Yes,
My lord, I filed
And,
three petition, my lord, subsequent,
Your rejection.
my lord, subsequent development has taken place because of the subsequent minutes have been published. That is why I.
Even if his petition became infructuous because of the revision of the comparative statement.
Lordship will see from his own record, my lord, what he wanted exactly. He wanted, my lord, the minutes in respect of the Jating and Rajnagar.
I have looked
Whereby
into
accepting the tender-
already inquiry report because you are doubting his document. They also accepting your prayer. They forwarded the matter to the deputy commissioner for inquiry.
My
You were
lord.
satisfied at that point of time,
My lord,
right?
yes.
Then they have annexed the inquiry report along with the affidavit.
yes, my lord.
So
Lord,
we
so far
don't find
his-
anything to keep this petition pending.
So far, his writ petition is
Oh,
con-
challenging valuation.
Lordship will see the,
Law is clear, Mr.
my lord, Lordship will see his prayer, my lord.
Only, my lord.
Only
I
what
think
he
answer
prayed.
remains.
Don't go to the all this technical please now.
Now, Lordship, for a moment, my lord, hardly 1 second will take, my lord. His prayer, my lord, what he wanted.
Okay.
Lordship will see that Prayed, my lord, meeting they held on 30/10/22 in respect of the Jatinga so-and-so ferry guard, whereby accepting the tender of respond declaring him as the highest bidder for Jatinga. The moment subsequent bid came, minors came, his case does not arise. It did not change.
His prayer still survives,
Yes,
declare
my
him as highest bidder
His tender should have been
for
rejected.
Jatinga and Rajnagar.
Quashed and on the ground of violation of the provision contained in so-and-so as well as the clause 4. But
Should
this,
not be set aside.
my lord,
Yes.
this-
2010-2022 comparative test.
that has
statement.
already gone.
And his prayer to declare him as highest bidder still survives,
Yes, my lord.
And entering in the, no, my lord.
still survives.
Comparative
That-
statement and
That
by the
declare me as the highest bidder.
Yes, my lord.
tender so-and-so Rajnagar ferry service should not be set aside for violating sale. And after entering the parties, only that much, my lord.
On the ground of violation of the conditions mentioned in serial number 7 of the terms and as well as clause number 4, that is your land clearance certificate,
Yes, my
Land
land
clearance.
revenue clearance.
clearance.
That, my lord,
And his prayer for to declare him still survives.
but it did not say, my lord.
Yes.
Yes.
But
Just.
should I point out?
So.
3, 4, 5, 6,
This
7,
tender
8,
meeting in
9,
respect of the respond number 4 as the
Ah.
highest bidder.
accepting
Jatinga
so-and-so.
comparative statement
Under
in
visual
process
examination.
and published in.
And declaring him 8 line.
Yes, my lord.
Tenders condition of so and clause 4 and to show cause the prepared tender committee Jatinga ferry
Wow.
should not be set aside and quashed for violating the condition of the NIT. After entering the parties cause make the rule action.
Peacock. All these 4 petitions instituted under Article 226 of the Constitution of India, have been preferred in respect of competitive bidding processes undertaken by the respondent Directorate of Inland Water Transport,
Yes, my lord.
Assam, for settlement of 2 ferry services, 1 Jatinga ferry service and 2 Rajnagar ferry service. Full stop. By trend record, as all the repetitions pertain to, as the subject matters of all the 4 repetitions are intricately connected with each other, all the 4 repetitions are taken up together at the admission stage at the instance of the learned counsel for the parties, as they have submitted that exchange of pleading in all the, for the purpose of adjudicating the issues involved in the repetitions are already made. Para. By a tender notice dated 18/7/2022. We go by the name, otherwise maybe there are different respondents in different everywhere. The executive engineer, Inland Water Transport Division. Silsor? Silsor. Invited tenders for leasing out 22 number of ferry services in two cover bid system from persons having experience in ferry business. Full stop. The two ferry services, comma, one Jatinga ferry service and two Rajnagar ferry service were amongst those 22 ferry services for which tenders were called by the tender notice dated 18/7/2022. Full stop. As per the tender notice, as per the tender notice dated 18/7/2022, the base value for Jatinga ferry service, base value colon 2022-2024 within bracket per year. For Jatinga ferry service was fixed at 2,28,392. Full stop. In response to the in respect of Jatinga ferry service, the tendering authority received 4 number of bids, including that 4 number of bids from page 33. 1, 2, 3, 4. Bachu Doctor bracket likhi dibo. The writ petitioner in WPC 30523. আৰু এটা আছে
835
And 10.
তাত 1 নম্বৰত আব্দুর রহমান আছে, 2 নম্বৰ বাছু ডক্টর ব্র্যাকেটত এই তিনটা লিখি দিব, 3 নম্বৰ ফকরুদ্দিন বরভুইয়া, within bracket the writ petition in WPC 8323 2022 and 4 Khairul Islam Barbia. Subpara. In response to the tender notice dated so and so. Subpara. Exactly Rajnagar ferry service over. Page 33 te ase 4 again 4. I think all 4s are same. So it will repeat over. It page 33 writ petition 8323 running page 33. After expiry, after the bid submission date, the tender committee constituted for the purpose of evaluation of the bids. The departmental tender committee. Constituted for the purpose of evaluation of the bids, held one of its meeting on 13/10/2022 in the office of the director, Inland Water Transport, some at Guwahati. Full stop. After scrutiny of the technical bids by the departmental tender committee in respect of Jatinga ferry service and preparation of a comparative statement, the departmental standing committee, tender committee found the technical bits of Bachu Datta, two, Fakhruddin Barbhaiya, and three, Khairul Islam Barbhaiya as compliant to the terms and conditions of the tender notice. Pushtam. Observing so, the departmental tender committee decided to accept the bids of these three bidders and the bid of the fourth bidder, PIZ, Abdul Rahman Mozumdar, was rejected as on the ground that he failed to submit proper land valuation certificate. Sapera. Just Rajnagar ferry service, Jatinga type. Just Rajnagar ferry service likhile hol. Baki khini repeat. Baki khini repeat. When it was published, Mr. Mohanto,
Tender, my lord, was
Okay.
published on 20.
the final on the basis of the comparative statements prepared by the departmental standing committee, the final list of bidders, final list of responsive bidders was published on 20/10/2022 by the Director of Inland Water Transport, Assam, on 2010/2022 question. Post up. Para. It is a case of the petitioner in the writ petition, WPC number 8323/2022, that after going through the comparative statement and the list of responsive bidders in respect of Jatinga ferry service and Rajnagar ferry service, he found a discrepancy in that the departmental standing committee had also accepted the technical bid of Bachu Datta, writ petitioner. In spite of non-submission of a number of documents in conformity with clause 4 of the online tender form and condition number 7 of the terms and conditions of the tender notice. It is the case of the petitioner in the writ petition WPC number so and so that the documents required to submit it in terms of clause 4 of the online tender form and clause 7 of the terms and conditions of the NIT was not showing on the online on the portal when tender technical bids of the bidders were opened on 9/8/2020. It is a case, the contention of the petitioner in the WPC number strength is that as per clause number 4 within bracket Roman 5 and which has been further clarified in clause 7 of the detailed terms and conditions of the tender notice. A bidder had to submit a land revenue clearance certificate from the concerned Mojaram. Full stop. Fair. MS Bora, where you have submitted the other affidavit?
8323, my lord.
888.
8323.
Eight.
8323, 2022, my lord.
Okay, and the other
835, another.
830.
Eight 2023, my lord. Both are
835. 835 photo. Please go ahead. Oh. Okay, we'll take up those. Mr. Monto, you submitted complaint, Director.
What?
You submitted complaint.
I submit.
Which paragraph?
My lord, is annexer 5 at page
44, my
44.
lord.
44.
Subject number 8323.
44.
44.
The petition in the writ petition 8323 2023 had thereafter lodged a complaint alleging inter alia to the fact that the bid of the bidder, Bachu Dotto, could not have been accepted as he did not submit the documents in compliance of clause 4 of the tender notice and clause 7 of the detailed terms and conditions of the tender notice. Full stop. The,
Minor 11:30.
okay. Okay, ফাইলটা লৈ যাওক দেখি নিবাৰ মাৰি দিয়ক আকৌ 2টা বজাত লাগিলে কৰি লম Yes, Advocate General, I have to halt. It will all of piece of We'll resume again.
Yes, Lordship, resume, my lord. If I do not come, my junior brother will come. My lord. Anyone, Lordship can pass a profit order, shake the practice. Obvious.
The
Other side.
I think it was the understanding. I don't know.
No, it was the understanding at 11:30. We'll inform.
MS Mohanto is there perhaps.
Will not give him that opportunity today to extend the interim order. Lord.
Interim order.
He will come to extend the interim order finally.
That is Gautam.
That is good.
And Gautam. Yes, MS Mohanto.
Let him start, your lordship.
Okay.
I'll take the notes.
So the other day I placed the affidavit. Now I'd like to take this honorable court through the tender notice.
Oh, 1 minute.
Yes, 523. The SOPD fund, that not the central government fund.
1 minute, 1 minute.
Lordship.
Repetition. 523.
523.
Industry. Where we stopped earlier?
We stopped,
Yes.
Lordship. I placed the affidavit of the state government.
State government.
State government. And now I have to place the FMP from the perspective of the state government, Lordship.
FMP. FMP. From the
Just to rephrase this honorable court.
some affidavit has been filed by Union of India.
Yes, Lordship. I'll place that also, one line from that. And we also filed an affidavit by placing the various notifications.
Yes, FMP.
So just to rephrase, our stand in our affidavit is that the fund has come not from the central government, but it is from the state's own fund, which is termed as a state-owned priority development fund, SOPD fund. And in our tender, we have very categorically stated the tender notice, if Lordship is pleased to look at.
Okay, let us see the tender notice. We're not seeing the tender.
Yes, page 25. Of the repetition, Lordship, 523.
Yes.
Mission Director Somogra Shiksha Ahom Kahilipara invites the following bids through GEM portal. The tender dated 13/1/23 for supply of dual desk and bench. Interested bidders may visit GEM portals and submit their bids. In this tender, when they go to the GEM, Lordship, they will find the products and eligibility criteria, which are very important. Page 31. The documents they can download from the portal. And GM stands for Government E-Marketplace. So the senior counsel plays page 26. The timings, opening, bid timings, etc. Minimum average annual turnover is 2,100 lakhs. And the products, Lordship will find that page 31, item, dual desk and bench, total estimated quantity, 69,350 sets, and delivery place, Lordship will kindly come to the last part, delivery of 4039 schools in 33 districts. And regarding the eligibility criteria, Lordship will kindly see page 32. This is very important because I am going to distinguish this tender with the tender which was considered by the coordinate bench, Lordship. In that coordinate bench, only the manufacturers were allowed to participate. In our case, Lordship would kindly see 2A. The bidders must be reputed manufacturers of furniture or authorized distributor duly certified by the principal manufacturer. So, two parts are there. We have widened it. The tender which was considered by the learned single judge before in the other case, Lordship, regarding uniform supply, it was only the manufacturers. Very restricted one. Here, it is a very wide one. So, bidder must be a reputed manufacturer of furniture or authorized distributor duly certified by the principal manufacturer. The bidder shall have to submit up-to-date trade license, etc. And the learned senior counsel, bidder must have finance minimum turnover of 20 crores in 3 financial years out of the so and so. So this is the financial status we are requesting.
So distributors should have also meet the this kind of
Yes, that means the market is wide open. Not only manufacturers, and the learned single judge in the other case decided the case from the perspective of only manufacturers were allowed to participate. And regarding the product details, Lordship will kindly find that serial number 21, product details. Tabletop with this MDF board. There is a specification.
page.
Page 37. Material desk bench, tabletop desk, seat bench, and backrest shall be made up to 18.0 mm thick MDF board. ISI number so and so or latest with 5 mm of from all sides laminated and edge to be fitted with 2 mm thickness in the etc. So this specification is given. Within this specification, there can be huge variety and qualities.
Now, this specification is also same in the other one
I'll just check.
because there are slight
Little, just I'll check it, Lordship.
difference in the stand.
Yes.
So just want to know.
Yes,
the
Lordship,
same
will,
thing. No, I don't feel that.
that at page 40. 18.0 MDF board, ISI with latest 0.5, same, Lordship, with laminated from all sides. The other part is also, the front modesty panel is different. Here it is 250 mm. In the state SOPD fund, it is 200 mm. State or in the state, it is 250 mm front modesty panel. On the other hand, in the central funded project, Lordship, it is 200 mm dia with 2 mm thick PVC edge branded. So there is a difference of 50 mm. Rest more or less it is identical. Yes, frame under structure, but within this
Height is also different.
Lordship.
Height is different. effective depth of seat is different. Minimum width is different. Radius of front seat, same. Degree, maximum
obliged,
single,
Lordship.
sometimes are different. Some parameters are
Some
different.
parameters are slightly different. And regarding the sizes and dimensions. Yes, yes, height is different. No, I spoke about the component. Now sizes, there's a huge difference.
Size different, effective depth of seat is different.
Yes, different.
Minimum, some things are different. Some
Yes,
specifications are different.
only the eligibility, let me check once here. What about the eligibility criteria? That is not eligibility. Yes, eligibility criteria page 35. Here authorized dealers are also allowed. Lordship will kindly see page 35. Insofar as the SOPD project, Lordship, it is distributor, authorized distributor. Here, the bidder must be reputed manufacturer of furniture, sole authorized dealer of the manufacturer. Any one can participate. So it is, even a dealer can participate. The other one was distributor. So it is more wider. So in the state fund, it is authorized distributor as well as manufacturer. In the central funded project, Lordship, it is reputed manufacturer as well as sole authorized dealer. In dealership, Lordship, there can be numerous.
No, sole.
That is a little bit confusing because
sole
in
means
Guwahati,
one.
there can be several dealers, but there can be only.
It is the company who has to identify the sole authorized dealer.
This is a very, I think that has no meaning because suppose one person from Dibrugarh comes, he is the sole dealer of Dibrugarh, but he will participate in the centralized projects.
Right, anyone, so only one.
Only one.
Only one. Suppose it is Nilkamal, only one.
So if I
Yes.
may continue, Lordship, then regarding the specification now, places of delivery page 39, various districts, the schools are all indicated. And they have annexed a part of the FMP at page 44 onwards. And also the general financial rules 2017. I'll come to the general financial rules little later. But if I'm allowed to place this FMP.
FMP is in full form. It entire FMP has been
FMP,
submitted.
I have given, Lordship.
No, this entire
FMP, yes, the same part.
running into 100 pages are part of the record.
Yes, Lordship, the total number of pages is
87 to page 87 to 202.
Anyway, okay. So here, Lordship, the other day I placed the two letters.
Okay, 2 letters. It is there.
Yes, 2 letters. And for a moment, if I take the central government's affidavit, it will tally. The central government affidavit, if Lordship is pleased to take up. Here, it was filed yesterday, paragraph 4. Because in the SOPD funded project, Lordship, our stand is very clear that it is a state government's project and therefore FMB will not come into play. Affidavit, paragraph 4, they have stated, the deponent begs to submit that it is also evident from paragraph 7.1 of the FMP, which stipulates that procurement activities under the Samagra Shiksha are governed by the procurement guidelines as provided in the Financial and Management Procurement Manual, subject to overriding provisions as contained in the General Financial Rules 2017 and Manual of Procurement of Goods Works 2017, as amended from time to time. As the grants under the schemes are governed by the various provisions of GFR, adherence to the GFR provision is mandatory wherever applicable or may not have been explicitly specified in finance, management and procurement fund. What I am trying to impress upon this honorable court is that as the grant under the schemes are governed, so there should be grant. Then only FMP will be applicable. My argument here is that there is no grant at all from the central government. So this will not apply. But my counter argument is from the FMP also we can do certain work.
Okay, so far that
The other case.
FMP is 90:10. That is what FMP says.
FMP says. So that is not a case here. SOP.
Okay.
It is
Yeah,
100%
clear.
state
It is
government
whatever state-owned
fund,
fund.
own fund.
It is the standing.
And it is schools are state government schools. So these two letters very clearly says that when there is this fourth line in page, the letter of Manish Garg, fourth line, with a view to provide guidance. What was the intention actually of this FMP? The objective. With a view to provide guidance and uniformity in respect of mode of release and utilization of fund, budgeting and financial reporting, accounting and auditing requirements and procurement procedures, etc. Under the scheme, this ministry has developed a FMP manual. This is the first letter, 12th September. The other letter also has the same thing. Say third paragraph, the FMP manual is intended to be used by the state unitary as a guide for budgeting and financial reporting procedures, accounting and auditing requirements, and procurement procedures to be followed throughout the country. The provisions laid down in the manual are mandatory and are to be followed by the states and unitary to ensure that funds are disbursed. So who disbursed the fund? The central government. Utilized and accounted for in an efficient and effective manner. I am confident that the FMP manual will help the state and union territories to bring financial rigor in the implementation of Samogra Shiksha and prove that to be a valuable tool as we seek to realize the goal and objectives of this centrally sponsored program. So when it is a centrally sponsored program, then FMP will cover. In the FMP, the other side place certain provisions, and I'd like to add a few within that. Page 13, participatory planning process. 2.5 page internal page 13, 2.5.2. Lot of submission emphasis has been given about community participation. What is community participation? I'll address on that point also. Participatory planning process scheme envisages a bottom-up approach of the planning as opposed to the top-down approach as it reflects the reality of grassroots level. The planning process has to be participatory in nature as planning not only creates a sense of ownership among the stakeholders, but also creates awareness and help in capacity building of personnel at various levels. The plan so developed should reflect the local specificity and educational needs and aspirations of the people based on consultative meetings and interaction with the community and target groups. It is necessary that there should be documentation of the process of preparation of habitation level plan as evidence of the fact that they are prepared at the habitation level through participatory planning. Participatory is a very wide thing, Lordship. At various levels, it is very clearly says, the first page, the planning process has to be participatory in nature as planning not only creates a sense of ownership among the stakeholders, but also creates awareness and help in the capacity building of personnel at various levels. So whatever level we intend to take up a particular project, Lordship, it has to be decided at various levels. When we say a particular product has to be procured through GEM portal and through e-tendering, do you expect the persons who are members of the school management committee are well equipped and trained to deal with this kind of procurement process. The hardcore financial persons of various agencies are also not well equipped, who are technical persons. We do not have that kind of persons in school management committee. I will place who are the persons who can be a part of the school management committee. The school management committee cannot look into the aspects of these technical aspects when a tender process has to be done through e-tendering or it has to be routed through GEM portal. So the community participation is not encompassing every aspect of having a school and delivering the process of education. So in each stage, there is a specific role. So these provisions they said, so we are seeing that a particular work can be done at various levels. So in one level, the government says that to have the school desk and bench, it has to be procured through this process of e-tendering. What will be the size of the decks and bench, or in case of uniform, what should be the color of the uniform? In that area, Lordship, the school management committee can have a say that the height of the bench and decks should be as per the size of the students or the class. Or regarding the uniform, the quality of the uniform, the color of the uniform, how many pairs of uniform are required. All these aspects, the SMC or the persons concerned can decide. The technicalities rigor and the rigors of financial aspects, are they competent enough?
I think chapter 3, financial management, it has taken care of everything. After how it is to be percolated down.
Yes, I'm coming there, Lordship. 3.1, the financial management. Allocation of resources. Budget allocation to the state and union territory under the scheme would be made considering the annual budget allocation for the scheme at central level and the visible proposals received from the state and union territory as per norms. The state plans will be apprised and placed before the project approval. These are regular events, Lordship, PAB meetings, project approval boards for approval of the state target along with the budget for that year. The budget allocation to the state are mainly depend upon the factors are given here. Commitment of the state with regard to the state plan, etc. Then preparation of perspective budget, procedure of release of funds, state government and implementing society, funding pattern. Funding pattern, Lordship is looking at it, 90:10 for the state of Assam. 3.6.1, fund flow arrangement for various activities, civil work, how it is to be done to state PWD, etc. Then accounting process is also given, cash book, ledger, etc. How it should be maintained, what procedure, double entry method based on mercantile system should be done. Are the persons in the school management committee are well trained or well?
They have also framed a suggested composition of school committee. Page 38.
Monitoring and internal committee and audit.
One member from audit and account, one member from education,
Yes.
3 experts from
Yes,
science.
this is here, but we have to read it from the perspective of the provisions of RT Act. Let us see whether these kind of persons are there in the school management committee.
This is suggested.
This is suggested. I'm coming with the RT Act. Whether the RT Act school management committee is tallying with the same number of persons here.
No, it is not telling.
It is not telling.
So that is why there is suggestion.
It is.
While the specific composition of SMDC may be decided by the states, the suggested composition of SMC may be as follows.
As be.
That is the
Maybe as follows. So it is not mandatory. If you
not
look at the
mandatory,
language, it is not mandatory.
not mandatory.
So one member from audit and accounts department, last one. So if we have 46,000 schools total in Assam, Lordship. So every school will have to be given this kind of persons which is not in my humble submission, practical at this stage. Then various committees are there. Now coming to procurement. Procurement in Samagra Shiksha for conjointly I am submitting this for the both the cases. Lord.
That is a difficulty I am finding.
Yes, Lord.
That is the
Because
difficulty.
if I am saying that this is not
Should have
required,
been both should have been in a separate for me to
I know,
concentrate.
I could understand, Lordship. That's why even now again, when I say SOPD, this is not required. I should not go to it actually.
Right. You are saying categorically that
It is not
is
applicable.
our fund.
It is our fund. But my argument may be for both. Now let us assume, or I can take it from the perspective of the other case. From the other case, I am placing this, Lordship. So I can segregate my final submission at the last stage, Lordship. Here, procurement in Samagra Shiksha for school education. The procurement page, internal page 50.
50.
Procurement in Samagra Shiksha for school education. The procurement activities under Samagra shall be governed by the procurement guidelines as provided in this manual, subject to overriding provisions contained in GFR 2017 and Manual for Procurement of Goods Work 2017 and Manual for Procurement of Consultancy and Other Services 2017. The grants under the scheme are governed by various provisions of GFR, and therefore adherence to the GFR provisions is also mandatory wherever applicable and may not have been explicitly specified in this manual. The principle of a public buying is to provide works, goods, services of the specified quality at the most competitive price. Lordship, this is the ultimate goal. In a fair, just and transparent manner. Procurement of all works, goods, and consultancy services under the scheme would be carried out in accordance with principles, rules, and procedures outlined in this chapter. Compliance
Basically, this is procurement of goods.
Goods.
Because works means, I think, civil works.
Civil work, Lordship.
And
goods is covered
consultancy
here.
is different.
Good and services
Consultancy is different.
different. So
So
we are
only it
concerned
is
about
goods.
goods here.
Yes.
Compliance of these procedures is mandatory so that ultimately results in efficiency, economy, fairness, transparency in procurement. With the subsuming, I'm skipping 7.3, now 7.4. The procurement activities under the new scheme will be at various levels. Lordship will kindly mark this. Various levels, and the bidding tender process as far as possible should be through GEM route. So whatever our finance department has notified, it is in tallying with the GFM, this FMP manual. As far as possible should be through the GEM route, e-procurement, and the broad features of procurement procedures under the scheme A. All the procurements will now be through single implementing society. Due to subsuming of the three schemes, namely SSA, RMSA, teachers education, and henceforth the procurement of goods, service, and civil work under so would be regulated through the single implementing agency. The first point itself indirectly says that one single agency will procure. If there is conflicting provisions in the FMP, that Lordship will have to take a call. But it is very clearly says single implementing society will do the procurement. So through the single implementing agency, in this case, Samagra Shiksha. The mission director has floated the tender. Number 2, procurement of goods, services, civil works has been mentioned at various levels, but however, for economy and bulk procurement, state can decide the level of procurement. 2, it was not shown by the other side. 7.4 Roman 2 was not placed. Our whole case lies on this provision. Procurement of goods, services, civil works has been mentioned in various levels, but however, for economy and bulk procurement. So bulk procurement is permitted under the FMP. So that is why my submission was, when we follow FMP, we are right. When we don't follow also, we are equally right. Options are given here. We cannot bypass the one provision and take another provision. When the options are given to the state that you can go for decentralized purchasing, you can go for centralized purchasing. That means bulk purchasing. So procurement of goods, services, and civil works has though been mentioned at various levels, but however, for economy and bulk procurement, the state can decide the level of procurement. So the other case is covered in my humble submission. Procurement of uniform being provided at the elementary level may also be done at the state, district, or school level. So state level we are doing in case of the uniform. This point was not properly placed, although it was quoted in the judgment, but it was not argued. So for its uniform also, procurement of uniform being provided at the elementary level may also be done at the state/district or school level through SMC, SDMC, but involvement and participation of the community should be encouraged. That is why I'm saying what should be the color of the uniform, what should be the quality, whether there should be warm clothes or summer clothes. All this has to be decided through community participation. But e-tendering, GEM is not contemplated to be done by the SMC as per the RTA Act. But whatever is proposed here or suggested here, as Lordship has, I am obliged that Lordship has pointed out that the technical persons from the finance also can be included, but that has not taken place, Lordship, till now. Now, procurement of textbooks at the elementary can also be made by a single tender basis. So textbook also in Assam.
This is clear.
Very
This has
clear.
to be
Lordship.
clear.
There is no ambiguity at all.
Regarding textbook,
Yes,
there cannot be
school-wise.
school-wise.
Uniform also given 3 options: district level, state level, and school level for uniform. And for procurement of goods, state can decide at what level it will procure, whether it can be bulk or it can be through school-wise. So all the options are available to the state of Assam. Now they have to point out which law we have violated. Portal, the following limits have been prescribed in the GFR.
7.7.
7.4.
7.4.
In addition, purchases, procurement of goods and services through GEM portal, the following limits have been prescribed in the GFR.
7.4.
Oh, Lordship, I'm sorry because there's a binding mistake. So I'm coming to page 51.
Page 51, yes.
Then civil works, we are not concerned.
7.7.
7.7. As a guiding principle, the financial threshold and type of procurement as provided in the GFR is given. So no tender or direct purchase up to 25,000, 3 members committee from 25,000 to 2.5 lakhs. Limited tender 2.5 lakhs to 25 lakhs. This is what they are professing by one calculation. They want that there should be limited tender. Open tender above 25 lakhs. Service contracts direct up to 2.5 and limited tender from 2.5 and open tender up above 25 lakhs. Additionally, the following financial threshold may be adhered to if necessary. Open tender by using e-procurement process for civil works, goods and services. So option is there for e-procurement above 25 lakhs and above. Then next page 52. In addition, purchases and procurement of goods and services through GEM portal, the following limits have been prescribed in the GFR. Row 3, above 30 lakhs in our case, through the supplier having lowest price meeting the requisite quality and specification and delivery period after mandatorily obtaining bids using online bidding. That's
This, I just want to know, this furniture,
yes,
this specification you have mentioned in the tender document.
Lordship.
Where from it has come?
These specifications.
Ah.
Lordship, I have to, but there should be some general guidelines on that.
Because you have,
The height is because one is for the primary schools, one is for the upper primary schools. That is why the difference in height is there. Yes, one is lower primary The SOPD fund, it is lower primary, and the other when the height is little bit more lordship.
SOPD standard, okay. It is, you can set it.
No,
So
the
far,
regarding the
this
height.
one 90% is to 10%. I am just want to know, this one is SOPD, right?
SOPD,
Because we have to
in SOPD.
go
it is for the
together, so just
Lordship.
this, say for example, where is the parameter in here?
Page 37. Page 37,
If
Product
I
details.
accept, suppose this is purely SOPD.
it is
And
purely
you can
SOPD.
set the parameter. But in the other one, say 90:10. This, is there anything specified by the
Regarding the
central government?
size.
Suppose IS code. IS means, I think,
Yes.
Indian
Yes,
standard.
Indian standard.
So that was also there
Yes,
in the other one.
Lordship.
Who has said this?
Lordship, I'll have to just take the instructions on this. There must be some guidelines. Otherwise, these parameters cannot be given. And
Because if it is 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 done by the central government,
Lordship.
then it will not be possible for the grassroots level furniture houses to meet the standard.
Lordship.
Because in the other one also,
Yes.
you have set the parameter IS. So,
No, they can, because how it can be done, because it should be either a manufacturer or authorized distributor or authorized dealer. So dealer will have the product from the manufacturer, and the manufacturer will get this certification. Either the manufacturer directly supplies or he sends his products to a distributor, or additionally, he can do it to the dealer also, sole dealer. The product will get the certificate from the manufacturer. They will do the necessary compliance to the concerned ministry or the agency to get the certification. So a local Nitu furniture on its own, his own supply cannot fulfill this requirement. If he is suppose taking the dealership or distributor of Godrej.
take the example of say Gohpur town,
Gohpur town.
right? Just to understand the
Yes,
concept.
Lord. Yes, Lord.
Now, this suppose it is community level or SMC, SMBC.
Lordship.
They float the tender, suppose.
Lordship.
Whether it is possible for that supplier or dealer to meet the standard.
He can meet if he has the dealership or distributorship of a manufacturer who has the products with this certificate. Suppose a Vishwanath Sariali dealer, he wants to participate in a Vishwanath Sariali Gohpur school. If he has the dealership, the product, it will be not his own production. He will get the product from, suppose he takes the Onoma, one company. They have the certificate. So the Onoma products, he will route it through his dealer and participate in the tender. The thing is that whether the persons of the school management committee can run and can use the technicalities of e-procurement and GEM portal. That is the core question. It cannot be done through that process because it needs high level of technical expertise. The ground reality is totally different. And therefore, if we look at the RT Act, a lot of trust has been given to RT. What exactly is the function of the RT, the school management committee? If Lordship is pleased to take section 21 of the RT Act.
Yes.
Section 21. A school other than school specified in subclause 4 of clause N of section 2 shall constitute a school management committee consisting of elected representatives of the local authority, parents or guardians of children admitted in such school and teachers. So three committee, public representative, the parents and the teachers will constitute the school management committee. provided that at least 3/4 of members of such committees shall be parents and guardians. Provided further that proportionate representation shall be given to the parents or guardians of children belonging to disadvantaged groups and weaker section. Provided that 50% of the members of such committees shall be women. Here, there is no indication that a person from the finance department or technically expert in the field of finance and accounting is to be included. So there is no such scope in the act. 2, the school management committee shall perform the following functions, namely monitor the working of the school. 2, prepare and recommend school development plan. And 3, monitor the utilization of the grants received from the appropriate government or local authority or any other sources. So they have to monitor the utilization of the fund if it is coming to the school, whether it has been properly utilized or misutilized or underutilized. Perform such other functions as may be prescribed. So they have to produce where is the prescription that the school management committee will have to do it. They can indicate from the FMP, but FMP clearly says there's a scope for bulk purchase. Whether a school, particular school has a SMC, whether they can go for bulk purchase. They cannot. They have to exercise their authorities in respect of a particular school only. It is not for the whole state. In that case, the district level, which is permitted by the FMP, that the procurement can be done at the level of school, it can be done at the level of district, and it can be done at the level of state. In the instant case, it is the state level procurement. So we are not violating any provisions of section 21, very categorical, Lordship. The coordinate bands decision, I will try to distinguish. All these aspects were not properly placed or discussed. Yes. Or latest. There is a guideline, Lordship, regarding the products from the Samagra Shiksha and Integrated Scheme for School Framework for Implementation. What level of certificate, Lordship will kindly see. The number is not telling because the number says ISI so and so or latest. So some other number is quoted. Other rules, the state rules. Now coming to 7.8, Lord. Page 52. The responsibility of implementation of integrated scheme. Samagra Shiksha rests with the state government through designated state implementing societies.
Internal page.
Internal page is 58, Lordship. 7.8.
Yes.
The responsibility for the implementation of integrated scheme. Samagra Shiksha rests with the state government through 7.8. This was not placed by the other side. I am placing it, Lord.
7.8. Internal page
52.
50.
52.
Yes, 52.
the responsibility for implementation of integrated scheme, the Somogra 6 are raised with the state government through designated state implementing society, and therefore the award and administration of contracts under the integrated scheme raised with these implementing societies. So here we are covered by this, that we are not barred. The SSA, Assam.
SMC, SMDC is also there.
That is their lordship. So options are there. What? Government can exercise one of the options. It is not that we cannot do it through the, in fact, earlier it was done. And the reason behind is it is not on record, but the main reason why the state government has trying to do, because the quality of that MB board varies. In some school, it don't last for 6 months also. This is the problem. And again, the other day, 3 days ago, the chief minister had a meeting with all the students. And the quality of uniform they were wearing was really horrible. And we are trying that appeal. We have to file an appeal against that order. But as the tender process was already over, so we are looking for an opportunity where we have to challenge. When the school authorities are procuring the uniforms, the quality level is not maintained. Some schools are having good ones, but some are horrible ones. Very inferior quality clothes are given to the students. And this was a first-hand information with the state government now. So the state has the options to implement the integrated schemes. It is an integrated scheme here, Lordship, because the state government is also giving the furniture, central government is also giving the furnitures. So state can do it through the implementing society. That means SSA Assam or SMC, SMDC. It should be ensured that the integrated scheme funds are used only for the purpose for which they are granted, and due attention for consideration of economy and efficiency, and without regard to political or other non-economic influences or considerations. It is better not to include SMC because SMC has the component of public representative, the local MLA. He can have his favorite contractors there. So here it is said, without regard to political or other non-economic influences. So the RTE says the local public representatives should be a part of the SMC. Coming to now 7.14.
Yes.
Level of procurement. Under Somogra Shiksha, the goods, works, and services required for implementation of the scheme will be procured at school community level, B, CRC, BRC level, district level, and
What
state
is CRC, BRC?
the community block BRC and CRC. One is community, one is cluster, and one is block.
Okay.
Cluster resource center and block resource center.
Okay.
Composition of few schools together at that level, Lordship. At one point there are a lot of teachers who gone and become head of the CRC. So once they become the CRC head, they dominate upon all the principals of the school. Also, they are teachers, but they are especially they are very important positions for the purpose of midday meal. Lot of litigations came before this honor. I'm sure Lordship has also done some of the cases for CRC. CRC, it was during Lordship 2008, 9, 10, 11, that time. So when the government wanted to bring back the CRC heads to their school, they do not want to come back. That community resource center, block resource center level, district level, and state level. So here also at D, these are not placed before the Honorable Court at the earlier round of litigation as well as in the inset. The procurement procedures as laid down by the state government rules or Panchayati Raj institution rules as applicable at each level shall be normally followed for procurement of the civil works, goods, services of the scheme. So what we are following, the 2017 rules and act. All civil work, etc., community level, district level, state level, let's say may desire, but due diligence should be exercised at all levels of procurement. So the whole intention is that it should be fair, it should be economical. (7.14)(2). The various level and items normally procured. Lordship will kindly see normally. It is not general. The various level, that means exceptions is permitted. The various levels and items normally procured are given below. The items mentioned against each are indicative, and implementing agencies may procure any items keeping in view of the financial norms prescribed under the integrated scheme, KGVP, girls school, SCRT, diet, etc. So this is indicative. This is not mandatory again in my humble submission. School uniform. School community KGV level, the procurement of uniform may not necessarily be entrusted at the school level, but should be at the as per the procedure mentioned in the manual. The state/implementing society may decide the level of procurement and the mode of procurement within the prescribed financial limits. So this is in respect of the uniform. So prima facie, the single judge's order did not consider all these aspects. The options are given. May I read it once more regarding school, because their whole case is based on that learned single judge's order, where the issue of uniform was taken into consideration, nothing to do with furniture. So in case of uniform also, procurement of uniform may not necessarily be entrusted at the school level. And we have getting a very bad result from that. But should be as per the procedure mentioned in this manual. That means at 4 levels we can procure: school level, block level, district level, and the state level. The state implementing society may decide the level of procurement. That means at what level we can procure. So we can take a call. That option is given to us. This is an enabling provision. This provision enables the SSA to take a call whether we would like to purchase it at the block level or at the school level or at the state level or maybe at the district level. And the mode of procurement within the prescribed financial limits. The prescribed financial limits, that means above 25 lakhs, it should be through e-tendering and open tendering. E-portal, GEM. So where is the fault for the state when we want to procure good quality products at a minimum cost? Now coming to Roman 2, school KGB related items may be procured: uniform, all civil works 3, furniture to government upper primary, secondary schools, higher secondary schools, procurement of furniture to be done by SMC, SMDC, equivalent bodies for rural urban areas. Here, this is their entrusting. So we have to read this Roman 2 sub clause 3 with the first part, 7.14.2. 7.14.2 says, the various levels and items normally procured are given below. The items mentioned against each are indicative, and the implementing agencies may procure any item keeping in view of the financial norms prescribed under integrated scheme, so and so, so and so, so and so. So these are all optional. Although the letter says all the provisions are mandatory, in the FMP, there are certain provisions which the authority has said that you can take a decision regarding which option, which level you can rely to be followed. So taking a decision, empowering the authority to take a decision is also mandatory. And while exercising that decision-making process or decision-making power, they have 4 options. 1 options they have adhered to, and will justify why we have adhered to, Lordship. So basically, these are the provisions. Then 7.16. The method of procurement suggested under integrated scheme. The method of procurement to be normally followed in Samagra Shiksha, open tender, limited tender, single tender, without tender, civil work by community participation. So the community participation, Lordship, is very clearly indicated. Civil work. If they want to construct a road in the school campus or a wall, the community persons can participate. Irrespective 7.16.2, irrespective of the above methods, which may be adhered as per the procedure and financial limits prescribed in this manual, but the following should have been given precedence. All purchase should be preferably made on GEM, and if anything is not available on GEM, e-procurement method should be adopted. it should be made mandatory to receive all such bids through a e-procurement portal in respect of all other procurements which are not available in the GEM. However, it is for the appropriate authority to decide the price reasonability, and in case of procurement through GEM, the method of procurement suggested should be strictly in line of the GFR. The states may, however, follow their own financial rules and financial ceilings prescribed under those rules in place of GFR 17 after the approval of the executive committee in this regard. Such approval should be mandatorily intimated to MHRD at the very beginning of the scheme.
Is there any approval? Suppose
It was not,
public procurement rules and act.
Lordship, I'll have to take an instruction, but without all these formalities, we never do anything. We cannot do because periodically every 3 months there is a PAB meeting.
Right.
All these decisions are taken in the PAB meetings.
Is it anything there in the pleading?
I have concluded, it is not there, and
Because-
they have not raised this issue also that that approval was not taken. Had it been taken, we would have
Many things
definitely-
are submitted which are not in the pleading.
Exactly.
Both sides are submitting.
No, we have indicated that we are doing this, it is permitted. Now, we are just elaborating the legal issues, legal points.
So
Factual
this is
point,
one of the legal.
it is very important, legal submission, but as if Lordship once said, whether we have the approval or not, we'll definitely,
Then that will prevail. Some public
that
procurement
is not
rule
re-
will prevail.
that will prevail.
If there is specific,
No,
because it is a condition precedent.
it is a condition precedent. So for a SOPD fund, this is not required.
No.
So for the
SOPD
central
fund,
fund, that is covered.
that is a different one.
That- When it is a central fund,
We are, my consideration is more into 90:10 because of the earlier decision also,
yes, Lordship,
right?
Lordship,
So that is why, because it is 90%
90%,
their fund.
Lordship.
And your
on
categorical
this
state
also-
in the other one is 100% is our fund.
Lordship, no problem. I can take the instructions. We can give the instructions on here itself. I'm sure, Lordship, without this
Because
approval,
it is a thing which is not to be missed.
absolutely, Lordship, this is one of the main condition. Just like we have to file a proper case to get it listed for motion. It is like that. It is as primary as it is indicated here. So
Because this Assam Public Procurement Act,
yes,
this has a bearing with this particular.
the state may however follow their own financial rules, and we are following this also. It is not that we are
Prescribed
bypassing this.
under those rules in place of GFR.
In place.
GFR again 155, 154, many
Yes.
things are said.
Lordship,
Many things are said.
many things are said.
154, 155, 150 they are referring to.
They are referring, but by in which way we have violated, they have not indicated. I was listening to their submission. I'll place that. By what way we are not following it. I'll come to that also, GFR, right now. So here, this approval is mandatorily taken. So I'm sure without this approval, the 90% will never come.
Yes,
It will never come.
and then this APP Act will prevail.
It will be.
Then it will be
Otherwise also, we are not bypassing this. In any case,
to make the things easier.
is Lordship. Yes, Lord.
If it is easier, why should we go into that?
Lord.
Because then GFR will not come.
GFR will not come.
Then we'll only concentrate on APP.
APP, they could not indicate which provision we have violated.
Then my task is easier.
Lordship trust will be easier. I'll definitely assist this honorable court in that respect, Lordship. I'm trying to get the information right now, Lordship. Now, misprocurement 7.29 they have placed. I do not know from what perspective. The goods, works, and services that have not been procured in accordance with the prescribed procedure outlined in this manual or other state government procurement procedures, as the case may be, shall be treated as misprocurement. The expenditure incurred on such procurement shall not be eligible.
Which
for
clause?
7.2.9, page 75.
75. $7.29.
This is the other side showing, that's why I'm referring this. It is no way connected here. If the contractors come and they are saying that they are not getting the payment, then this will have some relevance. The
Sure.
expenditure incurred by such procurement shall not be eligible for financing from the scheme funds. So then the fund will be stopped. So we'll not do certain things from which the fund will get lapsed or blocked. So
Is
basically,
there anything that before floating a tender of this magnitude,
Lordship,
any information from MHRD is required or taken?
I'll have
Because that has a vital bearing,
this approval.
because it is into crores.
It is into course. It
So
is
that
into.
is why
No,
anything.
There are 2-3 branches of finance department who are directly handling these issues.
Otherwise, we are not expert here.
Yes.
We do not
There are
think
space-
ourselves as experts.
There are two, I know, in finance, there are about 13 or 14 branches. One branch looks after all these funds which are coming for the state authorities from the central government, and which goes also to the 6 scheduled districts. Those funds also routed through that finance department.
If the certain procedural formalities have been followed
Yes,
before floating the tender, because we are after issuance of the tender,
Lordship.
right? And after issuance, we are all, but if certain pre-formalities,
No, the thing is very clear.
because
We
this
have
is
a-
an interpretation.
We have an act of 2005 that
That
that's
financial
budget
responsibility
management
budget
act.
management.
all this. The administrative approval must be there before floating it. Administrative
But
approval,
nothing has been stated here.
nothing, because that was not urged by them. So
No, otherwise, you could have
otherwise,
cleared it.
we have to, certain things we have to say it is implied. Suppose if they are harping that we have not followed any of the norms regarding
No,
floating of the
because
tender, then we'd have definitely disclosed everything.
levels of procurement for, then it is May, it is worded with
May, yes.
right? So if this procurement process has say complied with certain pre-formalities with correspondence from with the
Mini MHRD.
MHRD,
Yes, Lord.
and it would
We'll
have been.
we'll get the complete file. The file will
We should
definitely.
not have been.
No, I am sure, Lordship.
We are not expert how to float the tender, where to,
Yes.
from the level of, otherwise,
Now, the core issue here is, Lordship, whether it should be bulk purchase or it should be individual school-wise purchase. The
Because-
FMP provides that we can do it at 4 levels.
again, page 57, 7 point so and so, Roman 3, furniture to so and so. Procurement of furniture to be done by SMDC.
SMDC,
equivalent
but here
bodies
this is
or
indicative and under normally, the word normally is used there. So here it is not a normal situation. Number one. Number two, Lordship,
Because this standard has been prescribed again.
prescribed Lordship.
So
and-
you cannot go below par
Yes.
or below par.
Yes,
So that can be procured also at a committee.
yes, and the
Cluster
government will
level.
have a more proper bargaining power with the suppliers. Or the bids, it will be more competitive. Number 3, Lordship, suppose the FMB very clearly says it has to be done through e-procurement or GM portal. A school in the deep area of Dhemaji or in Dima Hasao, or in some very remote places in the
That
state
is
of-
also by me. That is also by me. Not necessarily. As far as possible.
as far as possible.
That is what is,
Because it is,
Both
is-
are-
yes, Lordship, this is applicable
it
pan
goes
India.
both ways. but
Some
if you-
areas are so
If
remote.
you say before the issuance of the publication of the NIT, it has, you have received a stamp of approval. End of the matter.
After- It is there.
Very good.
It is there. I have to see it, Lordship, before placing it.
Because both are permissible.
Both are perfect.
Both are
Both are
permissible.
perfect,
And if the standard is prescribed
Lordship.
and nobody go below par,
Nobody can dilute with the quality and the
Oh,
specification.
right, then
And the school management committee can monitor.
monitor. And
Monitor.
secondly, this IS code, etc., are to be done.
Standard.
So one way it is bulk purchase, the other way many dealers, 5,000 dealers may be benefited. Say
Yes, Lordship.
interest so far, standard will be same. I am putting
Yes.
to the Advocate General
From the welfare point of view.
because some stress is given to community level participation SMDC.
But they are not suppliers. They are not.
Uniform is whether that uniform had a prescribed standard in the other case.
I have gone through that. I think it has.
That
Yes.
this
I'll
because-
just check it, Lordship.
because here the question school uniform for every school different color different
Everything, Lordship.
shirt color is different, pant color is different, skirt color is different. So there could be a possibility of
The learned single judge consider the sizes will be different. That was also considered.
but here it is same.
Here it is same.
Here
It is
every
uniform.
desk and bench should be same.
The furniture, it is uniform. In uniform, it is not uniform.
All right. Uniform is not uniform, but
Furniture, it is uniform.
yes, uniform. So this can, and the standard is also specific.
Lordship.
Then this can go either way.
So Lordship, page 47, the GFR rules they have placed, and they have said that, I do not know from what point of view we have violated any of this. Rule 154, they have said, purchase of goods up to 25,000. These are normal.
Not violation per se. They are basically stressing on that it should be percolated to the
School management committee.
that is the submission. That is not per se violation.
Yes. And 173, page 51 says, transparency, competition, fairness, and elimination of arbitrariness in the procurement process. All government purchases should be made in a transparent, competitive, and fair manner to secure best value for money. This will also enable the prospective bidders to formulate and send their competitive bids with confidence, some of the measures, etc. So, when it is, why e-tendering is now promoted by the government? It is because of transparency and competition. That is why our, if Lordship is pleased to look at the affidavit which we have filed the other day, annexing the documents, page 90.
Affidavit that notification.
Additional affidavit, just bringing the four note. Yesterday we filed it.
Okay. Have you received, Mr. Goswami? Copy?
It was given to them, Lord.
Yes.
Page 90, 23rd November 2016. In partial modification of the office memorandum dated so and so, the governor of Assam is to re-notify para 4, 6, and 8 of the office memorandum. Para 4 says, henceforth all administrative departments of government of Assam and its subordinated directorates, offices, agencies, etc., including institutions receiving granting aid from government of Assam, shall resort to e-procurement, that website is there, with effect from 1st December 2016 for all tenders value 20 lakhs and above. So that is the upper limit or the minimum limit where e-procurement is required.
They are seeking to break down it to school level.
Yes,
Then
Lord.
para 6.
The value less than 20 also be procured at the above portal direction of the tendering authority, head of the concerned administrative departments. Then there is a modification in 2018. It was raised to 50 lakhs.
50. Discussion.
Yes,
May.
50.
Para 6 May.
Yes, when it is less than 50.
They are trying to break it down into school level
Yes,
and put the figure below 2.5, whatever.
yes.
And to say that it should be local level.
Local level. In offices also, certain offices, they have to procure certain, very few numbers of furniture. In that case, this is not done. Now, 2021, it was again enhanced to 25 lakhs or reduced to 25 lakhs from 50. Page
Para
90,
six, para six discussion is there.
procurement of goods
Me,
less than 25 lakhs. Now here, when it is bulk, it is crores.
bulk it is E, bulk it is E, no doubt
Yes.
about it.
And then thereafter, the notification, another notification, Lordship will find that page 96,
Yes,
it is 20 lakhs
yes, below it is me,
and above. 20 lakhs.
below it is me.
And now the GM portal notification, page 94. In pursuance of Rule 24(1)(2) Roman 4 of the Assam Procurement Rules 2020 and all other powers vested in the Finance Department on this behalf is hereby directed that the government e-marketplace GM is mandatory for all procuring entities for procurement of all goods and services that are available in GM except in cases specified below. All the emergency procurement urgent work as defined in the Assam Public Procurement Act 2017 and Rules 2020. Procurement in the 10 statutory autonomous bodies names are there. Procurement run through spot purchase and request for quotation, RFQ. Any items to be notified by the department with due concurrence of Finance Department, and the nodal officers are also given. So this is also notified.
We'll go into that if the approval is there,
Yes, Lord.
otherwise not.
From the central government.
Yes.
Definitely, Lord. So now let me place that case.
Yes, yes. I am not ready.
Another, if the central government's case affidavit, that affidavit I have not placed. The other affidavit,
Central government, yesterday.
no, not, I mean this, the central funded scheme. The other petition.
Yes, 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 yes.
Yes.
7967.
Yes, 7967. Here, one of their stand is that the annual turnover, we have given a very high value,
Notebook.
but we have stated in paragraph 4.
1 minute. Sige, Mike. Very good. Idea for this.
Listen and I am. Huh? Huh? 100%.
Running page?
Running page, it will be 79 if I'm not wrong, Lord. 79.
Yes.
Paragraph 4. With regard to the statements made in paragraph 7 of the decision, deponent begs to submit that the office memorandum dated 17/12/2002 of the CVC stipulates paragraph 5A1 that average annual financial turnover during the last 3 years ending 31st March of the previous year should be at least 30% of the estimated cost. Lordship will kindly come to page 95. The spirit has been taken from this. Average annual financial turnover during last 3 years ending 31st March of previous financial year should be at least 30% of the estimated cost. So whatever was the amount fixed in our tender notice, Lordship, it is 30% of the overall
This
value
is
of the.
civil and electrical. work.
Yes, that's a spirit has been taken. So next page, in strict compliance adherence to the seed norm as stipulated by the CBC, the tendering issuing authority kept the minimum average annual turnover at 9.52 crores. 30% of the bid value is 31.73 crores, and the figures is given, Lordship. Arithmetically, it has been done. Paragraph 7, we have stated the deponent begs to submitted the Government of Assam Finance B Department issued office memorandum dated 8/6/2022, which stipulates that GEM has been approved by the Government of India as the National Public Procurement Portal and has been made binding on all the departments of the Government of India by the General Financial Rules 2017. With the use of the portal, it has become possible to make procurement system quality, transparent, economical at the government departments. Pursuant thereto, all the procurements of state level of Samagra Shiksha being carried out through GEM portal. It would be pertinent to mention that clause 7.4 Roman 2 of the Financial Management and Procurement FMP manual provides that the procurement of goods, services, civil work, infrastructure has been mentioned at various levels, but however, for economy and bulk procurement, the state can decide the level of procurement. So what I have already placed, Lordship. Various levels are indicated or suggested in the FMP, but we can take a decision to go in a particular level of procurement. The level here is the state level or the bulk procurement for the entire state, 33 districts. Paragraph 8, second paragraph. The deponent the deponent begs to submit that the decision of the tendering authority to go for open tendering was based on the CBC guidelines, FMP, and the GFR 2017. That's why we are following everything, including the state. We are not bypassing anything. Be it stated that the GEM is open to all and the registered MSME can also participate in the GEM bid, including the impugned tender. It is further stated that the concession and or exemptions will be provided to the registered MSME as per the Micro, Small and Medium Enterprise Act 2006. The learned counsel for the other side, Lordship, placed this paragraph. We have already committed ourselves. Whatever is there in the act, that benefit they will get. Whatever they are not getting, let them indicate. They have not participated also. So when they are not participating, Lordship, and when we are going for a bulk purchase, Lordship, we have to lay down certain conditions to ensure that he is financially capable. The financial status, the stability must be ensured. And therefore, this turnover condition is always
EMD exemption is there.
EMD, MSME. I'm finding out. So whatever is there, we are going. It will not be denied. Therefore, the contention of the petitioner, the tender issuing authority, never considered the mandate of Section 11 of the MSME Act and issued NIT, depriving all the small units within the state of Assam in completely baseless and unfounded, and hence denied and devoid of any merit. Now, who were they?
What is the statement in paragraph 11 in the writ petition?
11, no, Lordship, it will be paragraph 11, yes, Section 11, paragraph 11. I'm just coming now. Paragraph 11, this is as per provision Section 11 of the MSME as well as state government should facilitate promotion and development of micro and small scale enterprise. Section 11 of the Act narrates the procurement preference policy, which reads as follows. For facilitating promotion and development of micro and small enterprises, the central government as well as state government may by order notify from time to time preference policy in respect of the procurement of goods and services produced and provided by the micro and small enterprises by its minister and departments, as the case may be, or its aided institutions and public sector enterprise. In this particular case, the tendering authority never considered the mandate of Section 11 of the Micro, Small and Medium Enterprise Act 2006 and the notice NIT dated 1/11/2022 depriving all the small scale units within the state of Assam.
It is there.
It is.
It is there, page 28. Exemption from EMD is there.
Yes. The bidder seeking EMD exam must submit the valid supporting documents for the relevant category as per GM GTC. Under MSME category, only manufacturers for goods and services providers are eligible for exemption from EMD. Traders are excluded from the purview of this policy. So here we have both traders as well as the manufacturers. So whoever is entitled, Lordship, they will get it.
No, micro, small and medium, it is confined to only manufacturer.
Manufacturer.
Traders cannot be.
Traders cannot be. So therefore, that is why my submission is that whoever is entitled, that means if the bidder is a manufacturer, he can avail the benefit. If he is not trader, he cannot avail the benefit of this EMD clause. Then paragraph 9, the deponent begs to submit that since the bid value 31.73 crore exceeds the financial threshold of 25 lakhs, the procurement type opted for by the answering deponent was open tender as provided under GFR 2017. The FMP under clause 7.7 reproduced the financial threshold and type of procurement as provided in the GFR 2017 as a guiding principle. The decision to opt for open tendering was in consonance with the GFR 2017 and FMP norms. So we are following, we are not bypassing it, Lordship. State is also followed, state law and the central notifications or these guidelines. Then paragraph 10, the deponent begs to submit that for administrative prowess and integrated scheme on school education has been prepared by subsuming the centrally sponsored SSA, RMSA and teachers education. The integrated scheme on school education has been operated through a single state implementing society called Samagra Shiksha. Being the single state implementing society, Samagra Shiksha Assam is well within its power, competence and jurisdiction to float the tender for procurement of goods and services, dual desk bench and at the present case for about 1,443 government schools across 30 districts. The other it is about in 33 is much more the figure, the state SOPD. The bulk procurement not only promotes competitive bidding, volumes are high, so rates should be competitive, but also helps ensuring uniformity in quality standard for goods supplied to all the 1,443 schools spread over 30 districts.
How do you distinguish it after specifying the parameters with IS code? Standard will be same.
Standard will be same.
Quality standard will be same.
Definitely, Lordship. It is not
because very strict standard you have put in the.
Yes, Lord.
So,
and it will be easier for the implementing agency to monitor the quality. Under this type of procurement, the norms and standards shall be set centrally at lowest possible cost for providing dual desk and benches to all the schools within the prescribed norms and quality. In view of above the contention allegation that petitioner that the tender issuing authority club 1,443 numbers of schools as one unit to favor some prefixed and interested bidders by depriving local entrepreneurs is completely baseless, unfounded and devoid of any merit and hence denied. My submission here is, Lordship, it is the tender is restricted only with the manufacturers. This submission or this plea of the petitioners may be tenable to some extent, but when we allow the dealers, the distributors who are local people, all the distributors and dealers are local people. The manufacturing unit may not be in Assam. In fact, there are a lot of manufacturing units are there in Assam also for furnitures, or assembling units are there in Assam. So this particular paragraph where they are alleging is totally unfounded. There is no need to club these 1,440 schools into one unit as the same are already under the control of one.
Ultimately, the competition is restricted to manufacturer. Page 35.
It is not, it cannot be lordship.
Yes.
Sometimes the manufacturer don't participate. If lordship looks at the general ten
Right. So he participates through the sole authorized dealer.
dealer
Now
or
here it is sole.
sole authorized and the
So-
distributors are
So
also
ultimately
there.
authorized dealer of the manufacturer.
Now, how many sole dealers are there? This is a very vague term.
How do you interpret this sole authorized dealer?
Sole authorized dealer lordship, I have.
Because manufacturer
Sole authorized,
stroke sole authorized dealer.
sole authorized dealer.
So
I understand.
there may be 1,000, say for
Yes, now sole.
Nilkamal.
Now the sole authorized dealer in
Either-
which area, which geographical area?
No,
Suppose-
this is for entire state.
For entire state, there cannot be sole dealer.
No, sole authorized dealer
Sole authorized dealer,
of the manufacturer.
he can,
How do you interpret? Because it is stroke.
lordship,
Bidder must be
In that
reputed
case-
manufacturer of furniture or sole authorized dealer of the manufacturer.
and this, yes, lordship.
Of a manufacturer, no. So basically, suppose Nilkamal, only one.
Lordship,
There cannot be two.
lordship.
Supreme, another one. Maybe.
Yes.
I want to go
Yes,
from
yes,
this.
yes, lordship. So according to lordship that the competition will be restricted amongst the manufacturers in broader term.
And the standard is laid down.
Standard is laid down.
There
Standard
cannot be any deviation below par.
below par, and on top of that, there can be 100 manufacturers of the same specification. So far as furniture is concerned, it is not that it is very restrictive or very limited. It's a wide area nowadays.
And now, is there anything to fix on the part of the implementing agency to fix a limit in the FMR?
In the
In the FMR? In the FMR, because so many financing things are there.
yes, lordship.
Is there anything that in the FMR that the state implementing agency can put the condition you may go through for school level, not restricted to furniture, I'm saying,
Lordship.
go through, but this is the thing you have to confine yourself and you have to follow this. Is there anything?
Till now, no. To the school authorities, school management committees, whether we have instructed them in that way.
Is there anything in the FMR? Because FMR, we are only on.
Yes. Financial management consultant.
Because
In the FMP.
FMP. Say for example,
Index. I'm looking at the
37,
index.
monitoring internal control
Internal audit,
audit.
5.8.
Right, 5.3 say. 5.3.1. Community-based monitoring is one of the strengths of the scheme, which can become a major weakness. Major weakness also, if not implemented properly.
In order to make the financial flow transparent at the school level, every school should display all the grants received and spent on civil and other than civil by the school, as well as enrollment, attendance, performance, incentive, and the details. All reports of information should be sent to the district project offices by schools and shall be displayed on the school notice board. In addition to this, SMC members have to inspect the scheme regularly. Parent as teachers association, community, local body can also inspect the school.
And they have put a suggestion also, audit member, audit and accounts,
Audit and account.
experts, then one officer from education department. So this is,
These are a utopian situation which has been contemplated here.
if the approval is there. That
The approval, Lordship. I'm trying to bring it.
Okay, we'll resume it too.
Approval.
May I take a moment, Milord?
Yes.
To your lordship convenience, both of us, that is possibly the last item 10. It may or may not reach.
I am in the process of dictating 4 other repetitions also.
That's why I am saying, we are saying we're not subject to your lordship convenience. Could it be after the vacation, say, which they.
No problem at all regarding deferment of the matter.
Can it be fixed on 16th, my lord?
5th,
16th of November.
16th, okay.
Okay.
কিমান আছে 16th?
16th or 23rd, no?
23rd.
Whatever.
P.K. Goswami, Senior Counsel. Estate by K. Kolita, B.C. Das. Estate by Disuti, okay, as soft by. Release the case 1611.
Interim to continue.
Interim continue.
I've got item number 8, madam. Time will be everything. Item number 8. I'm ready to do better.
I do not know how much time
Even I do not know, Lordship.
Advocate General will take. Tama. 16 or piece দিব.
Item 2.
Okay then, Two.
Item 2, my lord, the respondents counsel, he is not well, he left, my lord.
he left.
Private respondent.
And Soikia. At কিমান number item আছে এইটো? 8. Who is for the respondent? Mr.
And Brahma, Lordship.
N. Brahma.
Brahma, Lordship.
Did you what are they? Yes, S count.
The private counsel.
You are in which
He is in
case?
my case, my lord.
Oh, no. Who is the opposite counsel in the,
I'm for it.
okay, M city লিখে দিব. N Soikia.
Standing council industry, Kolita.
He is there also? Anyway,
I have not seen.
S count, running counsel, but a petitioner is present, Mr. M. Bormal, Arnett, counsel appearing for?
Industry department.
No, not in your case. You are appearing for whom?
Respondent 7, my lord. He's
Respondent number 7 has submitted that the leading counsel.
the assisting counsel, my lord, of
Okay,
7.
Mr. Who is the counsel?
H dash. And
S dash.
S dash.
As the learned counsel for the respondent number 7 is indisposed and has paid for listing of the case on another date. Full stop. Agreed date, anything?
After vacation.
After vacation date. In which case? Oh, S count. The name of land standing council, fishery department be reflected in the respondent side in the call list. MS. Right. 523, repetition.
Where the petition is 5. Item number 13, 12.
Lordship, I have received a copy just now. It is a general approval from the EC regarding expenditure of all the furniture at phase 1. It is still coming.
Yes. 553.
Let me get the printout of this, Lordship. Let me continue with the. Let me print out.
Mr. Gautam, how big is the ZFR? How big?
It's about 199 pages, bro.
You have any extra copy? Basically, introduction part is always required to understand. Because you have annexed only part of GFR. The introduction part was.
Lordship.
Yes,
So if we,
clear in the affidavit.
yes, I was in there. So according to them, we have clubbed all the schools is as one unit. In fact, all the schools are under one unit only. Page 85.
85.
There is no need to club this 1443 number of schools into one unit, as the same are already under the control of one administrative unit. That is Samagra Shiksha. Further, the deponent begs to rely the statement made in paragraph 9 that since the bid value of 31.73 crores exceeds the financial threshold of 25 lakhs, the type of procurement resorted to by the SIS, namely Samagra Shiksha, is open tender in strict compliance adherence to the prescriptions stipulated under GFR 2017 read with clause 7.7 of the FMP. Therefore, the contention is unfounded. Now, paragraph 11, what we are following, we have stated there. We have also stated about the GEM National Procurement Portal. Paragraph 13. The writ petition, the deponent begs to submit that in paragraph 15 of the writ wherein it was alleged that the tender authority had designed the tender in question in a manner which restricts participation. In the contrary, the petitioner himself sought for adopting limited tender enquiring quoting Rule 162 of the GFR. He advanced the argument in favor of his demand for limited tender enquiry by bringing the estimated value of the procurement per school at 2,19,889. By doing so, the petitioner wants to restrict or limit participation, which is against the spirit of CBC guidelines as well as Rule 173 of the GFR in respect of the public procurement. Pausing here for a moment, Lordship, what exactly is the status of the writ petitioner? If Lordship is pleased to come to paragraph 3. Paragraph 2, page 6. The petitioner is a proprietor of a firm in the name and style JK Group and Company, having its registered office in ward number so and so, having trade license. Paragraph 3. The petitioner's firm having a valid trade license for steel furniture and fabrication. We are not requesting for steel furniture. We are
One.
I'm sorry.
One. Hey, doctor, hey, we have to do. Not going to have a going on to go. Who does it? Econ minutes. Yes, yes.
So what he is saying, paragraph 3, the petitioner's firm having a valid trade license for steel furniture and fabrication has also been registered the firm under MSCME. So now he categorically states that he is a manufacturer of steel furniture and he is also into the business of fabrication, which he has stated in paragraph 5 again. The petitioner's firm has been dealing with the business of steel furniture and fabrication since its inception and accordingly as per the GMC Act rules by law under GMC. So, and also in paragraph 7, he says, the petitioner visited the GEM portal and obtained the bid documents from the portal and after going through the same thoroughly, understood the contents thereof. I'm very happy that he understood the contents thereof. As petitioner's firm deals with the business of steel furniture and fabrication work, went through the contents of the bid document in respect of the said tender. After going through the same, petitioner found that minimum average annual turnover of bidder should be 952 lakhs. Moreover, the estimated bid value of the said tender was 31 crores. Now, he categorically repeated in various paragraphs that he is into the business of steel furniture and fabrication work. And now Lordship will kindly come to page 40. Product details. He has concentrated only on the commercial or financial part of the tender, but the product details he have not gone through. If he had gone through, he would not have filed this late petition at all. Here we said desk bench backrest shall be made of 18.1 mm thick MDF board with so and so laminated from all sides to be fitted with 2 mm thick injection molded virgin polypropylene copy polymer. The deck should be Green Guard certificate of low chemical emission of VOC and carcinogens contributing to the healthier room. Then front model panel 18 mm thick MDF board or latest with 0.5 all sides laminated 200 mm D with 2 mm thick PVC edge branded. Frame, all side metal frames and cross connectors are made from so and so. So he is not into the production of any product which is tendered by this tender notice. So he is into the business of fabrication basically, and he is also into the business of steel furniture. Steel furniture and MDF products are totally different.
What is MDF?
MDF is a board, just like this board. There are some sawdust inside, which are chemically treated. So it is not steel furniture. Steel furniture, Lordship remembers from the 10th house when we take the steel furnitures for various functions. Those are steel furnitures. With the folding tables, folding chairs, those are steel furnitures.
What is this? This is central government.
This is central government. Samagra Shiksha, the central this agency's national guideline. The product specification is also there, a part of that. Everything is very streamlined, Lordship, with all the specifications regarding every stages of the whole scheme. I am dealing with a central government funded 90:10 case. So in my humble submission, although we have not stated this, but he does not have the locus to challenge this tender because he is not into that area. What he will do, he will purchase from the market and supply it. He is neither dealer, nor distributor, nor manufacturer of the products which we are looking for. He is a fabricator and he is a producer of steel furniture. This, in my humble submission, is a very strong argument on our side, Lordship. This limbo of argument, which we have not developed earlier, but while going through it, we have found that this is a very critical area on the basis of which the repetition is liable to be dismissed. He should be in that business, then only he can challenge whatever affairs the SSA is doing. He is nowhere connected to his business activities.
One minute.
And if it is 2.5, then the clause of the 7.57 says he wants it to be between 25,000 to 2,50,000, page 52 of the repetition, or FMB page 51. He has done all the calculations of the total value of the work divided by the number of schools. Then it comes to 2,19,000 and odd rupees per school. In that view, Lordship, he will come under the procurement type of 3 members committee. 7.7. So that will narrow down not only the competition, that will also leave lot of scope for manipulation and favoritism. So these 3 members can decide from whom to buy. Actually, he does not want business competition. He does not want to come to the playing field, which is can be termed as transparent, fair, and competitive. .7, serial number 2. So up to 25,000, no tender is required. Beyond that, from 25,000 to 2.5 lakhs, it is 3 members committee. 3 above 2.5 lakhs, it is 25 up to 25 lakhs, it is limited tender. Then also it is a limited scope. That wide participation is ruled out. Then paragraph page 89, the deponent further begs to state that the answering deponent had resorted to open tendering process using GEM platform to ensure maximum participation, transparency, and fairness in the procedure of public procurement. Paragraph 14, the deponent begs to submit that since the bid value 31.73 crores of the tender in question exceeds the financial threshold of 25 lakhs, therefore Rule 155 of the GFR 2017 shall not apply to the impugned tender notice. However, to ensure transparency, competition, fairness, and elimination of arbitrariness, the tendering authority have resorted to open tendering using GEM platform as per mandate of Rule 173 of the GFR rules. So we are following 173 GFR. That is why they could not indicate that which particular rule of the GFR we have violating or of the fundamental is FMB.
So there is only one writ petitioner.
There is only one writ petition. And the
Now-
whole process has been stalled for last so many months.
Oh, right.
Who does not, he is not into that business also. It is our fault that we could not highlight this at the earlier stage.
Because the uniform we do not know, but so far furniture is concerned. Mr. Goswami, is there a framework for implementation government of India? It speaks about the Bureau of Indian standard. That has to be followed. So for furniture also, they have said this much of standard you have to meet. So tender notice has specified IS code or latest. Are you in a position to meet?
We have not specifically stated in our petition.
Because
IS
tender notice,
code.
tender notice specific, because you have referred to all this, but this is also a framework for implementation. This one. It has specifically mentioned that this product furniture should also meet Bureau of Indian Standard, BIS, and it is there in the tender notice. Because I have to put the
Yes.
question. Because he is not in a position
Lordship,
to meet that standard, he has no locus.
exactly, Lordship.
That is
The submission made by.
no, these are all because you have referred to GFR FMP. This is also integral part of that framework for implementation.
And that has been.
But that is by
incorporated
Government of
in the-
India, Ministry of Education, MHRD. And it states that this furniture should meet Bureau of Indian Standards. And that particular clause, page 40, it is incorporated at least latest. We don't know what is the code. But school furniture, classroom chair, and table recommendation. So functionality code is there, BIS code. So whether there is anything.
We are qualified for the standard or not.
Oh,
Can manufacture of the BIS standard or not? I can take it to instruction also.
because that has to be a condition precedent,
Lordship,
cannot be condition subsequent.
Lordship.
If you do not have the,
Specific, the authorized certificate.
yes, because here is only one tenderer, not one prospective tenderer who has come. Because this issue is important.
Lordship,
If he does not have the
personal, one person,
one
not
person,
as a group.
not as a group, had it been a furniture manufacturer association, it could have been a different thing.
Lordship,
So it is BIS standard framework for implementation. And furniture is, and classroom chair and table. There is a standard specified in the Bureau of Indian Standard. And that is incorporated latest in page 40. If that you do not meet, then we do not have to go through all these submissions.
No.
It will fall.
That was first time argued, Lordship, we did not have the specification, that is why we could not.
No, it is incorporated here, page 40, tender document.
Lordship, I understand.
Product details, IS code is incorporated.
IS
Right.
code-
There is no pleading. And this document, because you have referred to FMP, ZFR, but this is also part of the scheme.
and this has been mentioned in the tender notice, the specifications given there.
Specification, all this we do not know, but BIS,
Yes,
Bureau of Indian Standard for furniture is in existence.
in existence.
And at least you could have said that I meet this BIS 1000, but BIS 2000 you have incorporated it wrongly. Have you got my point?
Yes, understand.
And he is also into steel furniture manufacturing, not this board.
Can I get this IS specification? So he is not into that business.
Exactly.
Then
No point of
no
going,
point of stalling the entire state.
Lordship.
So if this Ms. Borua, can you? Or Mr. Bora, S. Bora? That's all. If you have to meet the standard. Because here is only one. Challenging the entire process is only one person. We have to see from that perspective also.
One of the conditions that the specification has been prescribed as ADM board 200 mm and BIS 12406/203 or latest with 0 side laminated iman and thick for modulated panel. So we are also manufacturer of the BIS standards. We have confirmed. We have also confirmed that we are also manufacturer of the same standard material, BIS specification.
BIS.
Look, NIS.
Okay. But there is no pleading. Uddam. Okay. No.
We have taken the confirmation.
Let them produce a certificate, Lordship, that the product, they produce the product which we are asking for.
Specification, it is specification.
And the product also, Lordship, in my humble submission.
And regarding, let's say, the fabrication, what furniture fabrication,
No, I have to know. I do not know how a product gets.
can be categorized under BIS category.
How?
There is an agency, they have the
There is a
specifications, they do the
certificate agency.
inspection.
There is
There
there
is
is-
specific law.
agency which certified.
Ah.
There is a agency specification has been.
That has been raised in another rate petition, something dumping, anti-dumping. But yes, that BIS there is to be, how this can be certified?
Standard has been, as per my knowledge, to set information I have just now.
No, I have understood. A pencil, suppose
BIS standard.
BIS standard, it is marked there.
Mark it.
It is marked in the pencil. Mr. X can also manufacture a pencil. How can he claim that my pencil meets BIS standard? Without certification, it will remain as a claim only. It will remain as a claim. It will not, unless you get the
Certificate.
certificate.
Lordship, there is no, in the NIT, I think there is no that endorsement that this certificate should be there, BIS certificate should be there. Specification as per BIS standard. Material should be BIS standard.
It is in the
Standard.
there, and code number is there.
Code number is this, BIS standard. That is, Lordship, regarding panel. Front modesty panel.
No, I am, since you are referring to all this FMR, FMP, ZFR, this is also part of the homogrohika.
Lordship.
And where it mentions that the thing should be for furniture, IS standard is there, code is there.
I think there is no specification that the material should be certified by ISI. Standard is ISI standard. There should be certificate from ISI. This is not the Lordship. There should be BIS standard. Here also look at the MDF board. That is board in top board. Top board should be ISMN specification.
Okay.
Nice.
Yes.
And that thing has not been denied by the other party. Now, that is the first time it is argued, Lordship.
Okay.
And that is also thick MDF board. Modesty panel. Material should be used of that specification.
Yes.
Lordship, regarding this approval,
Very.
on top, procurement schedule for goods under Samagra Shiksha Abhiyan for the year 2023, elementary schools and teachers education, state Assam. Serial number, Lordship will see in the middle, F, provisions of 2 sets of uniform, then free uniform, then strengthening of school, NR up to highest class 8, furniture up to class 8,
1 minute.
total numbers,
B, C, D, E, F.
F. Below F, strengthening of school. Second one is provision of 2 sets of uniform, then strengthening of school, NR up to highest class level 8, furniture up to so and so. The total number of quantities is there. To open tender, e-procurement, estimated cost is there. And this is a part of the approval given in the EC meeting. And if we look at the
1 minute.
if we look at the FMP,
FMP, yes.
one particular provision was there where the state laws has to be followed. I'll just get that.
Yes, in 7 plus 7 something,
Yes, level of procurement 7.14.
7 point.
14. Point 1, 7.14.1, under Samogra Shiksha, the goods, works and services required for implementation of the scheme will be procured at school community level, CRC, BRC level, district level and state level. The procurement procedures as laid down in the state government rules or the Panchayati Raj institution rules as applicable at each level shall be normally followed for the procurement of civil works, goods and services of the scheme. So
On the 7.14.2 are normally procured, right? Then 7.16.2,
7.16.2. Yes,
that part below second paragraph.
the state may, however, follow their own financial rules and financial ceiling prescribed under those rules in place of GFR 2017 after due approval of the executive committee in this regard. Now, we are not bypassing, this is one, that is one part regarding the open tender and all.
Approval.
This is this is approval. This was placed in the EC meetings and part of, I have a whole bunch and it is not very legible. I have got it through WhatsApp now. If Lordship wants, we can place the whole.
Because it will change the,
No, it's the starting line is very difficult to read, but let me read it. This is photo. Minutes of the 11th meeting of Executive Committee of Samogra Shiksha Assam dated 24/8/2000 in the conference hall of the Chief Secretary, Government of Assam, Secretariat so and so. Yes, 22. After that, the tender was floated.
no, it received approval.
EC,
Yes,
there's a
You
minutes
see
of,
that-
on the first line. of
Due
this-
approval of the EC, such approval should be mandatorily intimated to the MHRD at the beginning of the scheme.
It has,
If you make a statement on affidavit, that's okay, then
we have intimated MHRD. Suppose we have not done, suppose, let us look at the negative side. Then also it will not dilute our case. So far as that may be a pure technical procedural lapse in case. But it was placed before the EC and EC has approved it. But here it is said, such approval should be mandatorily intimated for the very beginning of the scheme. Suppose we have not intimated, no approval of MHRD is required.
who are the, what is the
Yes.
executive committee?
Executive committee.
Formation.
The committee will be in the Chief Secretary's office, so Chief Secretary must be heading.
Is there anything in Samogra Shiksha?
I'll get the complete minutes, Lordship, but it was held in the executive meeting in
Which
the
item,
conference of
which
the Chief-
item,
Lordship,
which item regarding furniture
furniture F
in this minute?
in this minute, it's a part of this meeting, because I have got in piecemeal basis. Furniture is there up to class 8, so and so, open tender procurement, amount, etc.
And then
Procurement action 2020 to 2023.
B,
In some cases, it is limited tender, some is open tender, some is e-procurement. Lordship can see the third method, third column. Serial number, description of goods, quantity and numbers, method of procurement, estimated cost. So in method of procurement, various methods were adopted, limited one, open tender. Item wise.
where is the furniture? We are only furniture.
Furniture is there.
Which file?
F, Roman one, then F.
It is there. In the minute, it is there. That I have marked
In
already.
this chart, it is.
That I have marked.
But minutes, I could not go through it, Lordship, it is illegible. In infrastructure development, it is there.
Okay, let me see.
Page 24, Lordship may kindly see. Page 3,
Page 3.
page 3. Furniture was discussed. Reason expenditure, non-completion of tender in the process of furniture and KGB building. Action proposed was Prabhan.
Furniture,
Infrastructure development, serial number 5.
yes.
Total percentage of total expenditure against estimate. Here some references are there regarding furniture. At the last line, non-completion of tender process against furnitures and so and so. Some of the unspent fund have been surrendered in the next APWNB 2023-24, where sanctioned funds were not released from the state mission office due to various reasons, and issue no space for new constructions, amalgamation to nearby schools, and no requirement of infrastructure in base schools, court case, very low enrollment, etc. It is not done at the behest of one single person, Lordship. Everything is done through a process.
Lordship, if that is bring on record by an affidavit, Lordship, we can also go through that.
This is not their plea in their repetition that we have bypassed any of the provision specifically. And Lordship may.
No, it is the problem.
Lordship, I don't understand.
If the highest body takes
The chief secretary's
the
office is there.
decision to go for open tender,
Yes,
then the problem is lessened.
absolutely, Lordship. It has been decided in the EC. EC has decided in what mode the thing will be have to be done. Column 3. Lordship will see the chart. Method of procurement. At the top, procurement schedule of goods under Samagro Shiksha. It is not for just for sake this chart was made. This Excel chart.
Right.
And on top of that, what is this line 7.16.2 says? May I read it, Lordship, once more? In case if we do not want to follow the central government guidelines, then only this is required. May I read it? The states may, however, follow their own financial rules and financial ceiling prescribed, financial ceiling also. Under those rules, in place of GFR 2017, after due approval of the executive committee in this regard, such approval should be mandatorily intimated to MHRD at the very beginning of the scheme. We are not bypassing any 2017 GFR. Rather, in our affidavit, we have said we follow GFR 173. Very categorically, we have stated. Yeah, I placed that paragraph a few minutes ago. In paragraph 14, page 89. If we do not want to follow, then only this approval and discussion and intimation will be required. Paragraph 14, may I read it, Lordship?
Because FMP has both left open anything
FMP.
FMP. But
FMP,
if you have taken the highest body, executive committee has taken the resolution. No, this is not in the statement. So that is why.
no, whether that is also not required. This particular 16 point, that particular provision.
No, that this otherwise closes the debate. This otherwise, if you, if the chief secretary, the executive committee headed by chief secretary takes the decision to go for open tender and follow your whatever GFR, we do not have to discuss. We do not have to go by the GFR. It closes the debate. Otherwise, debate remains open, left to be considered.
Absolutely, Lordship.
That is what.
On top of that, I'll
Then-
try to get the file. I'll try to get.
Then
the file.
otherwise it is open for
But otherwise also,
Open gates.
if we look at the proviso of 7.16.2. Lordship may kindly please.
Seen it.
Here, basically what is said here, may I read the whole provision? Irrespective of the above methods which may be adhered as per the procedure and financial limits prescribed in this manual, but the following should have precedence. All purchases should be preferably made on GEM, and if anything is not available on GEM, e-procurement method should be adopted. It should be mandatory to receive all such bids through e-procurement portal in respect of all other procurements which are not available on GEM. However, it is for the appropriate authority to decide the price reasonability in case of procurement through GEM. The method of procurement suggested should be strictly in line of GFR. The states may, however, follow their own financial rules and financial ceiling. We are not following financial rules and financial ceiling. What we are following is the Procurement Act and procurement rules. Financial rules is issued by the finance department, but here it is tallying and it is gelling with the, and it is in sync with the provisions of the GFR and GM FMP. However, the states may however follow their own financial rules and financial ceiling prescribed under those rules in place of GFR. So when we want to follow our own rules in lieu of GFR, after due approval of the executive committee, so that is not required because we are not changing the rules or adopting any new rule in this regard. CHAS approval should be mandatorily intimated to MHRD at the beginning of the scheme. So that situation has not arisen in our case at all. Because we are not bypassing GFR or FMP. Paragraph 14, we have very categorically stated, Lordship, page 89 of our affidavit. With regard to the statements made in paragraph 17 of the writ petition, the deponent begs to submit it since the bid value 31.73 crores of the tender in question exceeds the financial threshold of 25 lakhs. Therefore, Rule 155 of GFR 2000 shall not apply to the impugned tender process. Further, to ensure transparency, competition and fairness and elimination of arbitrariness, the tender issuing authority has resorted to open tendering using GEM as per mandate of Rule 173 of GFR 2017. So we have specifically said that we followed a certain particular provision of GFR 2017. We are not using any state financial rules in lieu of GFR. So that decision of the EC is absolutely not called for. Regarding the standards and the specification paragraph 15 and 16. Paragraph 16, Lordship. The deponent begs to submit the sizes and dimensions have been set as per the recommendation of Bureau of Indian Standards IS 4837/1990 in respect of school furniture, classroom chairs and tables. The minimum width of the backrest was kept initially at 250 meters based on ISI so and so. However, in pre-bid meeting, it was pointed out that the minimum width of backrest cannot be 250 The matter was duly examined and found that the width of backrest should be 140 to 160 and accordingly the size has been amended and kept at 140 to 160
Is there any reply to this affidavit?
I was thinking about it. Don't give a reply, I think. There's a special bench actually going on in court now. So Santanu, my colleague, had to go there. Even I was to appear there. That environmental bench is going on.
Is there any affidavit in reply? No.
So that clinches our case, Lordship. Because there is no dispute about this. So the facts and the relevant rules are placed before this honorable court. Only thing which I have to overcome now is the judgment of the learned single judge in a coordinate bench. What was the case there? Just want to put a self validation. No, no, it would 1%. Low idea, sir. Precondition. 61, yes. Page 61. Here, Lordship will kindly see, it starts from page 58. Several repetitions were there. One, Sokrodhar Das and two others. Then, Assam Tailoring House and another. Then, Oshia Enterprise and Furnico and two others. So, their case, Lordship will kindly see paragraph 2. There are 3 read petitioners in WPC so engaged in the business of tailoring and supply of school uniforms through their individual SSI units based in the state of Assam. 2 read petitioners are proprietorship firms engaged in the business, manufacturing garments and supply of school uniform. The petitioner have their respective manufacturing units situated in the district of Kamrup, Guwahati. Then paragraph 3 regarding the SSA and RTE provisions. Paragraph 4, Samagra Shiksha, that presently what scheme is going on here. Paragraph 5, the scheme formulated under the Act of 2009 makes provisions for providing school uniform to students. As such, respondent number 3 had issued expression of interest dated so-and-so, inviting offers of empanel vendors for supply of school uniforms in the various schools in Assam. The EOI indicates that the estimated number of students would be 37,000 so-and-so, and the ceiling for each set of uniform has been fixed at 600. According to the official respondents, the purpose behind issuing the EOI is to prepare a panel of vendors so as to enable the respective school management committee to place their orders with them. It is their case that since the Financial Management and Procurement Manual, FMP, permits procurement of uniform at the state level, hence the process followed by the respondents cannot be found faulted with. Leading the argument so-and-so on behalf of respondent 3, the duty bound to follow the mandate of FMP, according to which community participation in procurement process was required to be encouraged by the implementing agencies. Dr. Sami said the impugned eligibility conditions, beside being contrary to the mandate of the FMB, also does not have any reasonable nexus with the purpose sought to be achieved, that is supply of uniforms to the school students, but has been deliberately inserted with a view that to outslux of local entrepreneurs such as the petitioners from the domain of the contract. Referring to the BIS standards as applicable in this case, Mr. Dotto had argued that by using 100% polyester material for uniform, the respondents have not only compromised the quality of school uniform, but also violating BIS standard. They have also ignored the interest of large number of school-going children, urging that ownership of a composite textile mill has no reasonable nexus with supply of school uniform. The learned senior counsel has argued that the entire procedure adopted by the respondent number 2 lacks transparency and has been deliberately designed for concentration of wealth for benefit of chosen few. Then paragraph 8. Sri K.N. Chode, learned senior counsel appearing for petitioner, has argued that clause 1 of the EOI, which lays down the eligibility condition of the bidders, is a direct conflict with clause 7.4, Roman 3 and 7.7 of FMP, and therefore the EOI is liable to be struck down on such count alone. Then last paragraph 9, opposing the stand by the official respondents in the counter affidavit that supply of poor quality uniform by the local entrepreneurs and their failure to supply the uniforms on time during the previous years has prompted the state to incorporate stringent eligibility condition in EOI. Mr. Chaudhary has argued that since the state has failed to substantiate such allegations by bringing on records cogent materials, an adverse presumption be drawn against the respondents on the above issue. Now coming to paragraph 14. DK Mr. Learned Counsel appearing to respondent number 4 in WPC has invited the attention of this court to the terms and conditions of the EOI to submit having regard to the volume of the work and overall value of contract. The respondent number 3 is justified in introducing the eligibility conditions in the EOI. According to Mr. Mishra, by floating the EOI, the respondent number 3 is merely seeking to create a panel of suppliers after due verification for their credentials. Since the indent for supply of the uniform would be placed by the respective SMCs directly with the suppliers without any intervention from the departmental authorities, community participation is automatically protected in the present mechanism. Mr. Mishra has further argued that this is for the first time that FMP has been followed in making procurement, and considering the diverse nature of requirement of uniforms coming from different schools, a centralized procurement mechanism would be most suitable so as to ensure time-bound supply of the uniform. On such ground, Mishra has prayed for dismissal of the petition. Then, paragraph 17. The basic contention of the writ petitioner is that there is not a single textile mill or manufacturer of garments in the entire northeastern India that would meet the above eligibility criteria. Therefore, it is apparent that the aforementioned eligibility criteria has been incorporated with the mala fide intention of excluding the local entrepreneurs from like the petitioners. Moreover, the impugned eligibility conditions restricts community participation and therefore contravenes the guidelines laid down in the FMP. So here, the turnover is at paragraph 16. It should be annual turnover of 100 crores per year. That was the requirement. Samagra Shiksha Manual of 2018 inter alia deals with the procedure for making financial transactions under the scheme. There is no dispute about the fact that the procurement process undertaken by the respondent number 3 comes within the purview of FMP, and therefore the process must meet requirement of FMP and the General Financial Rules GFR 2017. GFR 2007 lays down the general principles relating to expenditure and payment of money framed by the Ministry of Finances or Department of Expenditure, Government of India. Paragraph 20, Lordship, that letter has been quoted here, same letter I am placing. Paragraph 20, a reading of the communication dated 6/8/2018 issued by the Secretary MHRD, New Delhi, takes the matter beyond any pale of doubt that the state implementing agencies would be under a legal obligation to adhere to the FMP while making the procurement under the scheme. In the above backdrop, let me now examine the challenge made to the impugned eligibility conditions contained in the EOI dated so-and-so. Section 21 of the Act of 2009 provides for forming school management committee for each school other than the specified in so-and-so. Section so-and-so defines an aided school receiving aid or grants to meet whole or part of its expenses from the appropriate government or local authority. Subsection 2 of Section 21 of the Act 2009 lays down the function of the SMP, which includes tasks of monitoring the utilization of the ground received from the appropriate government or local authority or any other source. So this is highlighted here that the task of the SMC is to monitor, not to run the tender process. In exercise of power conferred under Section 38 of the 2009 Act, Rules 2011 has been framed, which is applicable in the state of Assam. Rule 13(1) of the rules deals with the composition and function of SMC for the purpose of Section 21 of the 2009. Rule 14 provides for preparation of school development plan for the purpose of Section 22 of the 2009 Act. From a careful scrutiny of the scheme of the Act of 2009 and the rules frame, I do not find any provision that vests the control of the appropriate government over the SMC in managing the affairs of the school. On the contrary, it appears that under the scheme of the Act and rules, SMC would enjoy sufficient autonomy in the matter of managing the affairs of the schools coming under its control. This is one of the findings. Clause 2 falling under Section 4 of the EOF mentions that the order of purchase for uniform will be placed by the SMC, SMDC of the respective schools, and the quantity of and the size of the uniforms, class-wise, gender-wise, student strength will clearly specified by the SMC of the respective schools in the order copies. Clause 3 of section 4 provides that payment will be made by the SMC, SMDC of the respective schools on receipt of uniforms as per specification, size, quantity mentioned in the order. Clause 3 further provides that no advance payment or part payment would be made by the SMC of the respective schools in any circumstances. Therefore, it is evident that even if a panel of suppliers is prepared by the respondents subject to the requirement of FMP, SMCs cannot be denuded of their autonomy to manage the affairs of the school, which would include their right to take decisions pertaining to procurement of the school uniform. What would be the sufficient to note that here is that it is the admitted position of fact that the uniforms are required to be supplied to the schools as per the mandate of 2009 Act, and therefore procurement of uniform is not a one-time measure, but it is a recurring event. Notwithstanding the same, the EOI dated 6/3/2019 does not indicate as to the period for which the panel sought to be created by the respondent number 3 would remain valid. Therefore, it is apparent that the life of the panel of vendors sought to be created under EOI is not limited by time. Chapter 7 of the FMP 7.4, etc., which are quoted, Lordship, here. All the procurements will now be through single implementing agency. One is stated, but it was not discussed later. All the procurements will now be through single implementing agency, subsuming of the other schemes, and henceforth procurement of goods, services, and civil work also under SCRT, diet, and other would be regulated through the single implementing society. Procurement of goods, services, civil works has though been mentioned at various levels, but however, for economy and bulk procurement, the state can decide the level of procurement. Very categorically, it is stated here. I have already placed. Then procurement of uniform being provided at the elementary level may also be done at the state, district, or school level, but involvement and participation of the community should be encouraged. So, Lordship, this has ultimately convinced the court that community participation for uniform, but for furniture, this provision is not there. Clause 7.7 of the FMP lays down the guiding principles that would have to be followed in the type of procurement provided in the GFR 2017. 7.7 clause is expected herein below that the various structures of finance as well as the corresponding procurement types. A plain reading of clause 7.4 and 7.7 would go to show that while the state has been left with the liberty to make procurement through single implementing agency, yet under subclause 3 of clause 7.4, involvement of the participation of the community has been encouraged. Coming to the previous page, clause 3 of 7.4, Lordship, it says, procurement of uniform being avoided at the elementary level may also be done at the state, district, or school level, but involvement and participation of community should be encouraged. So this is the reason why this case went in favor of the petitioners. That particular clause is not applicable in respect of furniture. I'm continuing further. In other words, 7.43 provides that the level of procurement may be decided by the implementing agency, but same should aim at encouraging community participation in procurement process. The aforesaid provision, in my opinion, lays down a policy statement of the government and therefore cannot be ignored by the implementing agency while choosing a procurement process. Clause 7.7 prescribes different procurement process as per the prescription of GFR 2017, depending upon the financial limit of the order. From clause 7.7, it is clear that an open tender is required to be invited only in cases where the value of procurement exceeds the financial limit of 25. So in our case, it is beyond 25, so open tender. In the instant case, as noted, there is no purchase order issued yet. The estimated number of students is also not a guarantee of any supply order of a particular financial value. Moreover, it is the stand of the department that all the individual orders for supply of the universe need not necessarily go to any one panel vendor. From the above, it is apparent that depending on the number of students, gender ratio, and size of uniforms, the supply orders to be placed by each SMC may vary from a few thousand to more than a lakh. In absence of any other criteria for determining the financial limit of the procurement, I am of the view that the financial limit of the procurement would depend upon value of the supply order and not on the volume of the business that might ultimately generate by the EOI. So one important aspect that there is no indication about the financial limit of the tender process, which is totally different in our case. We have very categorically stated it is 31 crores in one case, the other sitting, I think 9 crores. So this case, the facts are totally different. Going further, Lordship. Having regard to the prescription under clause 7.7 of the FMP as noticed above, I am of the considered opinion that requirement for issuing of open tender would arise only in case the supply order exceeds the financial limit of 25 lakhs and not otherwise. We have no quarrel on this proposition. This law, which has been propagated by this judgment, is equally helping the state of Assam in the present case. In case the supply order valued between 2.5 to 25 lakhs, the procedure prescribed under FMB is for limited tender. And therefore, in those cases, also there would be no necessity for open tender. Therefore, this court is of the view that even if the eligibility criteria contained in the EOI is upheld, even then, the procurement process has to remain confined to supply orders which are above the financial limit of 25 lakhs. Coming to the question of community participation, regarding the other part, Lordship, that 7.4 and 7.3, 7.7, Lordship, I fully endorse the view of the learned single judge here. If the quantum and the financial limit is above 25 lakhs, it is open tender. What they want the limited tender, which should be restricted with 3 persons. Their calculation, they have given that it should be 2,19,000 rupees each school wise. In their repetition, they have in 2-3 paragraphs, they have done that calculation. Paragraph 13, they have done the calculation. Paragraph 13, page 11. In the middle portion of paragraph, the bid value of the tender as per the tender document has been shown as 31 crores 73 lakhs. And the number of school has been shown as 14,143, which reflects that the procurement threshold for a particular school will be below 25 lakhs. That is 31 crores 73 lakhs divided by 1443 comes to 2,19,881.10 paisa. So if we follow this, then it will be page 69, the chart in the judgment. Serial number 2. Page 69, because I am in the judgment, Lordship. That chart is mentioned in the judgment. Serial number 2, 3 members committee, certificate to be furnished as per rule so and so, above 25,000 up to 2.5 lakhs. So 2 lakhs 19, it will come under. So their whole endeavors is that it should be done through 3 members committee for a value of 31 crores. So I'll not use any further language to condemn that process, Lordship. Now coming back now to the community part, paragraph 33. Coming to the question of community participation, as indicated in 7.4, Roman 3 of the FMP, it is to be noted herein that although various types of procurement have been envisaged under the clauses, yet the expression community participation has been used only in case of procurement of uniform. So in our case, it is furniture. So community participation in procurement of furniture is not envisaged in the rules as well as in the policy. When an expression has been deliberately used in a particular clause, the court, while interpreting the same, cannot presume such expression to be superfluous, but would be obliged to give due weightage to the same. Oxford Dictionary defines community as joint ownership, state of being shared or held in common. Although the expression community participation has not been defined in FMP, yet by employing the dictionary meaning, the word community, I am inclined to hold that the idea behind including the said expression in subclause Roman 3 is to promote wider participation of the members of civil society in the matter of procurement of uniform. So this community, this argument, if it is to be accepted also, it is applicable only in case of uniform, which is not the present litigation all about. The subject matter is totally different. Then Tata Cellular, etc. Coming to paragraph 37. Sorry, paragraph 36. What follows from the decision referred above is that the term of a tender is a policy matter and therefore the government must be permitted ample latitude to settle the terms and conditions in respect thereof. So I also endorse this view, it is helping us. There can be hardly any debate on the settled law that the state must have the freedom of entering into contract. But what must be borne in mind is that the procedure adopted by the state or its instrumentality to award a government contract must not only be reasonable, just and fair, but also must also aim towards serving the larger public interest. In the name of freedom of entering contracts, the state cannot claim to be given unfettered discretion. So they have to indicate where we have exercised unfettered discretion in laying down the process and the type of procurement in the instant case. FMP as well as the GFR both provides for procurement through 4 types: school level, block level, district level, state level. So what we are doing is, it is through state level. One of the options we have adopted, or we have opted for one of the options given under those manuals as well as the rules. So we cannot come under this particular term of unfettered discretion. Discretion is given to us. It is limited. It is controlled discretion. We cannot go and find out a 5th way of procurement process or type. 4 types are given. We can adopt one. We cannot create a 5th or a 6th type of procurement process. If we do that, then we'll come under the scope of unfettered discretion. Now, whatever discretion we are exercising, it is given, it is controlled by the rules as well as by the manual. Paragraph 37. In the present batch of writ petition, it has been alleged that the eligibility condition prescribed by the UI is to exclude the state-based entrepreneurs. The departmental record produced by the Learned Standing Council does not indicate the basis on which the eligibility criteria indicated in the UIA has been settled. There is also nothing in the departmental record to disclose the reason for changing the method or level of procurement, nor is there any indication as to why owners or textile mills having minimum 100 crore turnover have been preferred by the department for awarding the contract. We have given the CBC's guideline and the CBC's notification of 2002, where it is said that 30% of the total estimated value of the work has to be the turnover, has to be the turnover, Lordship. So when it is 31 lakhs, it is around 9.52 crores. And in case of Lordship, 9 crores, it is 3 crores something. So we are following a particular principle. If that principle is bad in law, they have to specifically challenge the notification issued by CBC. It is a common paragraph. Sorry, paragraph 30 I have read. Paragraph 40. For the reasons stated above, this court is of the view that the decision to incorporate impugn eligibility criteria is for the purpose of excluding the local entrepreneurs from the realm of the contract. If that be so, there can hardly be any doubt that about the fact that the decision of the respondent number 3 is wholly unfair, irrational, unreasonable, hit by Article 19(1) of the G. In that case, the tender was only by the manufacturers. I'd like to point it out. Only the eligible
mill 100 crore.
It is the manufacturer, the other tender, that furniture. Yes, page 62. Sorry, I'm sorry. Paragraph 17. No, paragraph 79. So. Yes, the paragraph 17, I'm repeating, Lordship. The basic contention of the writ petitioner is that there is not a single textile mill or manufacturer of garment in the entire Northeast that would meet the eligibility criteria. So it is only from the textile mills and the manufacturers. Here it is a distributor as well as the dealers. So this particular judgment was restricted to uniform, which is not the case. For uniform, separate norms has been set in the FMB of 2018, and also the status of the writ petitioner and the prospective bidders was restricted to mill owners only or manufacturers only in respect of the uniform, which is not the case in the instant case, Lordship. In the subject matter here is relating to the tender in which we have allowed participation of not only the manufacturers, but in addition to the manufacturers, the dealers as well as distributors are also allowed to participate. They are also eligible, provided they fulfill the norms set in the tender concept, which also includes the financial capacity. Thereafter, paragraph 51. In view of the discussions made above, this court is of the considered opinion that the impugned eligibility criteria contained in the EOI, in the facts and circumstances of the case, the Honorable Court has also considered this and specifically issued this. In the facts and circumstances of the case is arbitrary and hence unsustainable in law. Having held as above, this court would have ordinarily gone into the strike down the EOI. However, having regard to the mandate of clause 7.4 read with 7.7 of the FMP and keeping in mind the interest of the school students balancing the equities, these writ petitions are being disposed of with the following observation. The respondent number 3 may prepare a panel of vendors for supply of school uniforms as per the impugned EOI, but the operation of the panel shall be kept confined to only those individual supply orders, the net value of which exceeds 25,000 or 25 lakhs. So it is indirectly supporting our case, this judgment. Each order must be beyond 25 lakhs. In that case, the Honorable Court did not interfere. The panel so prepared shall also remain valid only for a period of 1 year from the date of notification. So a particular period is given. The supply orders valued less than 25 lakhs. The principles and procedures laid down in clause 7.7 of the FMP read with GFR 2017 shall be followed. So when the work order is less than 25, the other provisions of law will follow. So the Honorable Court did not touch the main core issue, which was before the Honorable Court at that point of time. That is, if as the value was not indicated, if the value was indicated in that tender process, suppose it is 100 crores. All this B, C, D would not have come. Only thing is that there was no value indicated. It was a tender for empanelment. There is a huge difference. When empanelment is being done, Lordship, the empanelment can be for 3, can be for 10. So that whichever school, whoever wants to place an order. In the tractor supply cases also, we always have empanelment of 5 to 10 number of manufacturers, so that there is no shortage and no time lapse in completing the supply process. D. In matter of procurement of school uniforms, the respondent number 1, 2, and 3 shall not in any manner encroach upon the autonomy vested upon the respective SMCs under the Act of 2009 and 2000. So basically, community participation, that aspect did not come into in the final reasoning. And the Act very clearly says that the SMC can monitor the financial aspects. So this judgment, in my humble submission, will not trouble this Honorable Court in deciding. Our case may be decided independently without taking reference of this, although they may be arguing that this case is helping them. But if we look at finding at paragraph 51A, which clearly allows what was going on. If the school is ordering uniform for beyond 25 lakhs, the settled position was that whatever was initiated by the department or the authorities or Samagra Shiksha, SSA Assam, it was not interfered with. So this is there is a huge distinguishing factors, Lordship. Only manufacturers were there in the uniform supply case, whereas now we have three different categories: manufacturers, distributors, dealers. In the other tender notice, no financial limit was prescribed. In our case, financial limit is prescribed. It was never argued that 4 options were available under the FMP, which was never discussed by the learned single judge in that judgment. In our case, we are clearly and repeatedly placing before this honorable court that 4 options are available to the state, and state can exercise its discretion in choosing one. And while doing that, we have to follow the norms as indicated in the financial rules of 2017, as well as the financial manual also. We have not violated anything. They are vaguely saying that we are violating 2000 procurement rules and act. I have gone through it, Lordship. I could not find anything which is in violation. So they have to first indicate which provision of law so that I can give a proper response. I cannot go through the whole act and justify. If they indicate that we have violated any of the norms here, then Lordship will definitely come up with appropriate legal arguments. But in the air, we cannot do anything, and it will not be anything except wasting this honorable court's valuable time. In support of my case, Lordship, I would like to financial approval. Now we have a better copy, Lordship. I am placing it. I have not gone through it. But the thing is that approval is not required. Otherwise, also approval of the department, everything is here. Financial approval. In fact, now with so many scrutinies, Lordship, and so many PILs, when there is a query from the AG office, every year audit is being done. Initially, 25-30 queries come. On the basis of those queries, PILs are being filed. To meet up the queries, certain time is required. In my office also, AG office here also, I get 13 to 15 queries every year. So I have to meet it up. Query does not indicate that there is anomaly. And with so many financial norms, Lordship, nobody will dare to do anything fishy. And when this kind of tender, when everybody looks at it, and all the persons, especially the students, the guardians, the local stakeholders, everybody is watching what is happening in the local schools. So nobody can do anything which is not permissible in law, number one, and they cannot also give substandard equipments. In support of my case, Lordship, I'd like to just refer to 2-3 judgments. I'll not place it anymore. 2012, 8 SCC page 216, Michigan Rubber India Limited versus State of Karnataka. Lordship must have gone it several times till now. So the relevant paragraphs here will be Michigan Rubber, paragraph 13, 15, 21, 23, 24, and 35.
SCC page?
Page 216. Paragraph 13. May I read it, Lordship? Paragraph 13. In Union of India versus International Trading Company, similar circumstances as held in Sweden, while the discretion to change the policy in exercise of executive power, when not trammeled by any statute or rule, is wide enough, which is imperative and implicit in terms of Article 14, is that a change in policy must be made fairly and should not give impression that it is done arbitrarily or by any ulterior criteria. The wide sweep of Article 14 and the requirement of every state action qualifying for its validity on this touchstone, irrespective of the field of activity of the state, is an accepted tenet. The basic requirement of Article 14 is fairness in the action by the state and non-arbitrariness in essence, and the substance is the heartbeat of fair play. Action are amenable in the panorama of judicial review only to the extent that state must act validly for a discernible reason, not whimsically for any ulterior purpose. The meaning and true important concept of arbitrariness is more easily visualized than precisely defined. A question whether the impugned action is arbitrary or not is to be ultimately answered on the facts and circumstances of a given case. A basic and obvious test to apply in such cases is to see whether there is any discernible principle emerging from the impugned action, and if so, does it really satisfy the test of reasonableness? Where a particular mode is prescribed for doing an act and there is no impediment in adopting the procedure, the deviation to act in a different manner, which does not disclose any discernible principle, which is reasonable itself, shall be labeled as arbitrary. Every state action must be informed by reasons, and it follows that an act uninformed by reason is per se arbitrary. Paragraph 17. On the condition, I have not given paragraph 17. 17 is very important, Lordship. On the condition laid down by prescribed minimum turnover of business, the challenge made on behalf of the petitioner in Association of Registration Plates case was that fixing such higher turnover for such new business is only for the purpose of advancing the business interest of a group of companies having foreign links and support. That was impossible for any indigenous manufacturers of security plates to have the turnover of approximately 12.5 crores from the high security registration plates, which were sought to be introduced in India for the first time, and the implementation of the project has not yet started in any state. On behalf of the Union of India, the state authorities and the council appearing for the contesting manufacturers, in their replies have tried to justify the manner and implementation of the policy contained in Rule 50 of the Motor Vehicle Rules. On behalf of the Union of India, the learned ASG submitted that under Rule 50, read with Statutory Order 2001, issued under Section 1093 of the Motor Vehicles Act, the state governments are legally competent to formulate an appropriate policy for choosing a sole or more manufacturers in order to fulfill the object of affixation of security plates. The scheme contained in Rule 50, read with Statutory Order 2001, leaves it to the discretion of the state concerned to even choose a single manufacturer for the entire state or more than one manufacturer region-wise. It was pointed out that such a selection cannot be conferred any monopoly right by the state on any private individual or concerned. He further pointed out that tender conditions were formulated taking into account the public interest consideration and aspect of high security. While considering the above submission, 3 judges' bench held that in matter of formulating conditions of a tender document and awarding a contract of the nature of ensuring supply of high security registration plates, greater latitude is required to be considered by the state authorities. Unless the action of tendering authority is found to be malicious and a misuse of its statutory power, tender conditions are unassailable. On intensive examination of tender conditions, we do not find that they violate the equality clause under Article 14 or encroach on fundamental right of the class of intending tenderers under Article 19 of the Constitution. On the basis of the submissions made on behalf of the Union and the state authorities and the justification shown for the terms of the impugned tender conditions, we do not find that the clauses requiring experience in the field of supplying registration plates in foreign countries and the quantum of business turnovers are intended only to keep indigenous manufacturers out of the field. It is explained on the date of formulation of scheme in Rule 50, issuance of guidelines thereunder by the central government, there was not many indigenous manufacturers in India with technical and financial capacities to undertake the job of supply of such high dimension on a long-term basis and in a matter to ensure safety and security, which is the prime object to be achieved by the introduction of new sophisticated registration plates. The notice inviting tender is open to response by all, and even if by one single manufacturer is ultimately selected for a region or state, It cannot be said that the state has created a monopoly of business in favor of a private party. Rule 50 permits the RTO concerned themselves to implement the policy or to get it implemented through a select approved manufacturer. Selecting one manufacturer through a process of open competition is not creation of any monopoly, as contended in violation of 19(1)(g) of the Constitution read with clause 6 of the said article. As is sought to be pointed out, the implementation involves large network of operations of highly sophisticated materials. The manufacturer has to have embossing station, etc. So the Honorable Supreme Court permitted it. Paragraph next 43. Certain preconditions of qualification of tender have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work. Article 14 of the Constitution prohibits the government from arbitrarily choosing a contractor on its will and pleasure. It has to act reasonably, fairly, and in public interest in awarding contract. At the same time, no person can claim a fundamental right to carry on business with the government. All that he can claim is that in competing for the contract, he should not only be unfairly treated and discriminated to the detriment of public interest. Undisputedly, the legal position which has been firmly established from various decisions of this court cited in the bar is that government contracts are highly valuable assets, and the court should be prepared to enforce standard of fairness on the government in its dealing with tenderers and contractors. The grievance that the terms of notice inviting tender in the present case virtually create a monopoly in favor of parties having foreign collaboration is without substance. Selection of a competent contractor for assigning job of supply of a sophisticated article through an open tender process is not an act of creating monopoly, as is sought to be suggested on behalf of the petitioners. What has been argued is that the terms of the notices inviting tender deliberately exclude domestic manufacturers and non-new entrepreneurs in the field. In the absence of any indication from the record that the terms of conditions were tailor-made to promote parties with foreign collaborations and to exclude indigenous manufacturing, judicial interference is uncalled for. After observing so, this court dismissed the writ petitions directly filed by this court and transferred the case to the High Court. Then paragraph 23, 24, the Tata Cellular, etc. cases, and 35. I'm not reading, Lordship, but I'm referring to other paragraphs also. Paragraph 35. As observed earlier, the court would not normally interfere with the policy decision and in matters challenging the award of contract by the state or public authorities. In view of above, the applicant has failed to establish that the same was contrary to public interest and beyond the pale of discrimination or unreasonable. We are satisfied that to have the best of equipments for the vehicles which ply on roads carrying passengers. Second respondent thought it fit that the criteria for applying for tender for procuring tires should be at a high standard and thought it fit that only those manufacturers who satisfy the eligibility criteria should be permitted to participate in the tender. As noted in various decisions, government and their undertakings must have a free hand in setting terms of the tender, and only if it is arbitrary, discriminatory, malafide, or actuated by bias, the court would interfere. The court cannot interfere with the terms of the tender prescribed by the government because it feels that some other terms in the tender would have been fair, wiser, and logical. So the law is well settled, Lordship, in this field. So whatever we are doing, we are following the norms. So this judgment, all the other judgments which are discussed here, has and Lordship in recent case. Lordship judgment. In all Assam Police Housing Corporation Contractors Association case, Lordship made certain observations. Very recent judgment on 9th of this month. Interim, but observation is there. And at a particular case, it's of turnover of this. Paragraph 14. In so far the decision of Sakradhar Das, if I am not wrong, that uniform case is Sakradhar Das is concerned. The said decision is clearly distinguishable in view of the fact that the bidding process was with regard to supply of school uniforms, and the impugn clause in the tender notice had restricted participation to manufacturers having composite textile mills of having minimum annual turnover of 100 crores. Here ours is very wide. Same way it is distinguishable. The court in Sakradhar Das had taken a note of the Financial Management Procurement Manual FMP, more particularly clause 4, 7.4 and 7.7 thereof, which contain restrictions of issuing open tender only in case of supply orders exceeds financial limit of 25 lakhs and not otherwise. It was observed that in case supply orders valued between 2.5 to 25 lakhs, the procedure prescribed under the FMP was also for limited tender, and therefore there is no necessity to go for open tender. The court had noticed that in the matter of regarding procurement of uniforms, community participation was necessary, and it was in that context exclusion of state-based entrepreneurs from the impugn clause was found to be discriminatory and violative of equality clause contained in Article 14 of the Constitution. In the case in hand, each of the contract bodies related to construction of EPC mode valued at 7 crores 2 lakhs so and so, and the same are to be completed within 16 different locations. So Lordship has distinguished with this particular police contract with the contract of uniform. Identically, our contract is also totally different from the uniform contract. The basic fundamental differences are there. So I am relying upon Lordship these observations in distinguishing the case of uniform in my present case also. So I am highly obliged for giving me a patient hearing for last 2 days. This is my humble submission that there is no material which can attract merit for any allowance of the writ petitions. All the writ petitions are liable to be dismissed, whether it is a state fund or central fund. Highly obliged, Lordship. May I take leave?
Yes.
My colleague will be here.
May it please, your Lordship.
My lord, from what I could hear from my learned advocate general, my lord, the case which the learned advocate general is trying to project is what is the merits of the particular tender? How state stands to benefit by adopting the procedure which is impugned in the procedure. My lord, I am afraid that that is not the issue which falls for your lordship's kind consideration. We are not at all concerned with how state stands to gain by the impugned tender process. And my lord, another very fundamental error which my learned friend has committed is when he is referring to judgment in Michigan rubber. My lord, fishery settlement under fishery rule, awarding of contract under the FMP, these are not per se commercial transactions. This has gotten, my lord, societal impact in it. I can appreciate in a tender for my lord, what number plate will you say? Registration plates. That's a pure and simple cutthroat commercial competition, my lord, where the Honorable Court has, consistently taken the view that the decision of the, my lord, employer should be respected or due deference should be given unless there is a clear case of failure of justice in a given case. So therefore, that is why it is said, my lord, a decision is an authority for what it actually decides. Therefore, my lord, I will respectfully submit, even this All Assam Police Housing Corporation, I do not know how that helps the state's cause, my lord. In any case, that was while passing an interim order.
That has not been finality.
No, while passing an interim order, lordship has distinguished the judgment in the uniform. My lord, my learned friend has also made a submission that the tender of the uniform was different, here it is different. No, my lord. Only difference is there the procurement was made based on partly central fund, partly state fund. Here the procurement is made solely on the state fund, as they propose, as they profess. Now issue is,
In your repetition,
ah,
in your,
in my repetition,
in the other repetition, 90-10.
it is covered. Other repetition, there is no question, my lord. And my lord, my learned friend has also referred to last part of the judgment, uniform judgment, to show that the single judges, the coordinate bench view support the state because above 25 lakh it has been permitted. Well, in what context it has been permitted? Then my lord, the state, they never resorted to, that procurement of 25 lakhs and above. State confined to that the SMDC business. After the learned single judge judgment in uniform, till date, my lord, every year, my lord, SMDCs are getting the work. They have not floated any other tender. Therefore, my lord, I think to say that the judgment helps this, I am, my lord, appalled by it. That can't be. Similar argument we are advancing here. Our case is, irrespective of the fact whether the procurement is made based on central government fund or in the state government fund, you are bound to follow FMP. Now, my lord, why I'm saying so, if your lordship will kindly have the constitution for a moment, my lord. Please come to entry 7 of list 3. Contracts, including partnership, agency, contract of carriage, other special forms of contract, but not including contract relating to agricultural land. It is a subject enumerated in concurrent list. Now, my lord will kindly come to Article 254(2).
Yes.
Where a law made by the legislature of a state with respect to one of the matters enumerated in concurrent list contains any provision repugnant to the provisions of an earlier law made by the parliament or an existing law with respect to that matter, then the law so made by the legislature shall, if it has it reserved for consideration of the president and received the assent, prevail in that state. So in case of a statute, my lord, then my lord, the bill has to be reserved for assent of the president. Otherwise, my lord, this will be repugnant. Now, my lord will kindly come to the writ petition for a moment. Page number. Petition. Oh, no, I'm sorry, my lord. I'm referring to the FMP. Heavy luggage, state or heavy luggage, 130. No, my lord will kindly come to 134. 61 internal.
Yes.
Please come to that subpara. State may, however, follow their own financial rule and financial ceiling prescribed under those rules in place of GFR after due approval of the executive committee in this regard. Such approval should be mandatorily intimated to MHRD at the very beginning of this scheme. Well, I'll respectfully submit, my lord. This principle has been borrowed from 254(2). My. Am I clear to your lordship, my lord? In case of any repugnancy, it will be bad. But if the bill is reserved for assent of the idea is what, my lord? Idea is though we are federal in structure, we are unitary in form. Now, what had happened, my lord? The fund is essentially being given by the government of India. The government of India wants that procurement process throughout the country should be uniform. And since the money is coming from the central government has prescribed a procedure. Either even doing that procedure, you can't do anything else. These are all fundamental questions, my lord. So, my lord, here, if you want to deviate from the procedure prescribed in either finance rule of 2017 or FMP, you can do so. But you must seek prior permission from the executive committee
Which executive committee?
of the, my lord, central government. After due approval of the executive committee in this regard.
No. If you read together the paragraph.
State may, however, follow their.
Is of the state.
Ah,
Such approval should be mandatorily intimated to the central government.
yes.
So
Hmm.
it indicates
Ah.
the executive committee that the exact question I asked to the Advocate General,
Okay,
Advocate General
Ah.
already.
Okay.
Mr. Gautam is aware.
Yes, yes.
So I asked, then he produced a document that executive committee had taken a decision, though not available, but some document is placed. That taken a decision, but he is not aware whether this is approval has been
Prior.
approval is prior, whether it has been intimated to the
Ministry of.
but he has developed thereafter the argument that even if it is not there, then we are not violating ZFR and FM.
That is the case.
That is, he
Ah.
immediately on that point,
Ah.
that was
No.
argued.
Ah.
So far, executive committee is concerned,
Hmm.
that is headed by the chief secretary of the state.
Oh, yes, executive committee
Right.
of the state.
State.
Ah.
So far, that to that extent, I am satisfied because something is produced.
Okay. No, my lord, then.
That
should
second
ma-
part is there.
Ah.
Second part, he said, readily I cannot say.
Yes. So, my lord, therefore, my humble submission is, now, my lord, there are two ways. One, if there is a repugnancy, if we go by the spirit of 254(2), it will be bad.
Basically, the spirit.
Spirit. But in a given case, my lord, where the procedure for deviating is not followed, then what happens? Now, at end of the day, lordship will weigh where the public interest lies. But I'm sure, my lord, if a particular individual gets this contract, it is given to hundreds of, small dealers throughout the state, it will definitely be in the public interest. That is a consideration which perhaps, my lord, the FMP6 objective which the FMP 6 to achieve. Why they are saying, my lord, there should be community participation. The idea is, my lord, one must have sense of ownership. Because let us not treat these things as chalo, government ka cheez hai, jo hona hai hoga. That attitude, my lord, perhaps government wants to do away with. But government wants to invoke is a sense of ownership, my lord. Now, this can be achieved only when, my lord, the procurement process is decentralized. Now, my lord, can we discount the fact that the basic idea behind this, my lord, FMP is decentralized procurement? Otherwise, my lord, what meaning do we give to the constitutional amendment, whereby, my lord, the primary education has been made a part of the fundamental right? In fact, my lord, it is offshoot of that amendment that this amendment was made in the Act of 2000, RT Act, my lord, where, my lord, section 21 was inserted, which envisages an entity called SMC, which, recognizes some role of the SMC. Now, when a central act is giving some role to a particular entity, can the state by an executive order, my lord, take away that role? Now, at end of the day, my lord, every legislation is presumed to be in public interest. When by central act, my lord, this role of, SMC is delineated, how can that role be tinkered with by an executive order, my lord, even by that executive committee? I don't think, my lord, this is permissible. This full subsection to the school management committee shall perform the following functions. monitor this working of the school, prepare and recommend school development plan, monitor utilization. of the- Yes,
RTA.
RTF, my lord.
There is one more thing.
Yes,
Paragraph 16 of the affidavit in opposition in the other case.
okay. 16, my lord. Dependent express on a size and dimension have been set as per the recommendation of the instructor in this condition. No, my lord, this objective can be achieved even by procurement made through SMDC also. This by itself cannot be a ground to do it. No, my lord, lordship will kindly appreciate this. There is a role for this SMDC or SMC. Now, my lord, it has been, conferred by a parliamentary legislation. Now, can that function be, my lord, taken away or abridged by an executive function order? I don't think so that is permissible, my lord. Otherwise, my lord, the purpose of coming out with this FMP and financial rule will make no sense. The idea is decentralized procurement. Can anybody say no to that, my lord? And your policy would show you are trying to, enrich a particular section of the people at the cost of the, my lord, hundreds of vendors or hundreds of, my lord, small-time businessmen who are doing this business. This cannot be permitted. Well, the fact that they are going to procure furniture which is BSI conforming, my lord, that does not make the proposed NIT, my lord, valid, or it cannot confer any extra legal efficacy. The issue is, my lord, end of the day, there is a central government's policy which envisages a decentralized purchasing, and whether that can be deviated from and in what circumstance. The FMP itself says in certain situations it is permissible. But then, my lord, whether those situation is, prevalent in this state, or the justification which has been pleaded, my lord, whether that conforms to the requirement. Now, if your lordship would kindly have the affidavit filed by the central government, I think, my lord, whether it can.
Yes, Mr. Devchuri, you are left.
My lord,
to be
I just
hard.
take 5 minutes time.
You are left to be hard.
Now, kindly come to that affidavit at page 88, my lord.
Okay, yes.
It refers to your lordship's order dated 21/8/23, whereby your lordship specifically posed this question from submission advanced by learned counsel for the parties. It appears that two of the relevant issues will be whose decision, that is central government or state government, will prevail in formulating the terms and conditions in the NIT for procurement furniture for the schools under Homogra Hikha. So that was the question lordship specifically posed. Now kindly come to page 89, para 3. It is submitted that scheme of Homogra Hikha was launched with effect from so-and-so after subsuming the centrally sponsored scheme of so-and-so, so-and-so, so-and-so. Thereafter, various suggestions were recommended by National Education Policy. Accordingly, the same scheme was revamped as Homogra Hikha to align with the various recommendations of National Education Policy of 2020. Kindly see, my lord, the idea was to align the, my lord, scheme in tune with the NEP. It is stated that to provide guidance and uniformity in respect of utilization of funds, accounting and auditing requirements, and procurement procedure, etc. under this scheme, a financial management procurement manual has been developed by the Department of School Education for its uses in the states and union territories and implementing agencies. So it is the clear-cut stand of the central government, my lord. This is a scheme or this is a procedure which has been prescribed for bringing in uniformity in the utilization of funds and procurement. And for what? For the fund to be utilized by the states and union territories. Because, my lord, the proceeds which will be paid to a supplier, that will be a fund arising out of this. So for proper utilization, my lord, it was felt as a way, because my learned friend was referring to policy decision. This is the policy decision of the central government. The policy is that it should be implemented by the states and union territories. Then paragraph 4, that the deponent begs to submit, it is also relevant from paragraph so and so, which stipulates that procurement activities are homographica, are governed by procurement guidelines as provided in the financial management and procurement manual, subject to overriding provisions as contained in the general financial rule and manual on procurement of goods and works as amended from time to time. As the grants under the scheme are governed by various provisions of GFR, adherence to GFR provision is mandatory wherever applicable and may not have been explicitly specified in such. That the deponent begs to state central fund under this scheme is released to state as per provisions of GFR 2017 order guidelines issued by the Department of Expenditure with regard to revised procedure of release of fund of centrally sponsored scheme and all other orders issued in this regard from time to time. So, my lord, central government's affidavit is very clear, my lord. On the contrary, the central government stand is that these are all mandatory. So, if these are mandatory, my lord, where is the leg room for the state to deviate? And well, my lord, governance is a very tricky issue. At times, my lord, there could be exceptions to every rule. But then, my lord, such a stand must be justified and it must inspire your lordship's confidence. Merely because, my lord, they are going to procure BSI standard conforming furniture, that by itself will not make the, procurement, my lord, in tune with what is prescribed by the FMP. There's one more thing, my lord. If your lordship would kindly come to page 36 of the writ petition, my lord. Now, some meaning has to be given to this, my lord. Page 36, clause 20. The contracts shall be governed by and interpreted in accordance with the laws of the Union of India. But not some meaning has to be given to this while adjudicating the dispute, my lord. Now, it can so happen, my lord, supposing there is an arbitral proceedings arising out of this, then, my lord, whether substantive law of Union of India will apply or not, that could be one of the way of looking at it. For example, my lord, specific relief act, transfer of property act, all this. My lord, it can also be viewed from another angle. That is, the FMP and all, though these are not statute, but these are nevertheless law within the meaning of Article 73, my lord, of the Constitution of India.
This speaks about contract,
Contract.
clause 20.
I know, my lord. Contracts. Substantive law of India. Specific relief can all.
So after execution of the contract.
No, what I'm trying to say, my lord, I think, my lord, there is an indication that the governing law or the, my lord, governing law includes everything, my lord. Law includes the legislation under Article 246.
Prior to contract, it is Article 14.
Article 14.
Primarily.
Yes.
And subject to other policy
That's
decisions.
all. And policy.
Other policy decisions.
Now, my lord, my learned friend.
Policy can be discernible from the whatever guidelines.
Yes. Yes.
These are
Correct. No, my lord, my learned friend, Advocate General, when he was referring to Michigan rubber, he was laying emphasis on the policy. What is the primary policy? The primary policy is, my lord, FMP. The policy guidelines are enumerated in FMP. And the second is, my lord, decentralized purchase. Now, even if it is a state fund, if you want to make procurement, what is the harm in adopting that procedure, my lord? Why you should opt for procedure which is against the spirit of the my lord policy.
To be frank, this FMP also goes sometimes here, sometimes there.
It recognizes state's power,
Yeah.
but then my lord, state must have that financial ceiling. Where is it? They don't have. That's why I said, my lord, there is nothing like absolute proposition. There will be ifs and buts. That's why it is said, my lord, there's an exception to every rule. It is also said, my lord, what is legal may not be just. What is just may not always be
Yes.
legal. So these are there. Overall, my lord, therefore, to sum up my argument, my lord, my humble submission is the policy decision of the central government as far as procurement by Samogra Shiksha Abhiyan is concerned, it is a decentralized policy, my lord. In other words, the procurement policy should be made by SMDC. Now, this is a mandate following from a law made by my lord, the Union of India, in exercise of power under NP 7 of the list fee. And you as a state, when you want to make the same provision in respect of the same subject, you may do it. But your law must not be repugnant to the central law or the central prescription. Or else, if you do not, in that process, if you do not comply with sub-article 2 of Article 254, then you, invite the wrath of what we call doctrine of repugnance. So therefore, my humble submission is that state has miserably failed to justify its procurement by a procedure which is not consistent with the FM. And the state's procurement by FMP has got many advantages, which the FMP itself envisages, and that is the object of the act. It is something like, my lord, in a fishery settlement under the Assam fishery rule, if we take the view that highest bidder must be given, then, my lord, that will be a wrong view. So earning of revenue is not the objective which is sought to be achieved by the fishery rules. What is sought to be achieved is that these backward classes of people, they must be engaged in some activities from which they can derive their livelihood. So, my lord, therefore, the decision which govern the per se commercial transactions, like, my lord, meat, Michigan rubber, Tata Cellular. But Tata Cellular is again, my lord, it's a cutthroat commercial transaction. Those principles will not apply here. My lord, why it will not apply is a very simple example is, my lord. There it is said, merely because state has entered into a contract, there is no requirement of complying with Article 14. There is in para 70 or 71, that statement is there. That is said in the context that end of the day, when you are entering into a business, as a state, you cannot claim any special privilege. Because there you are
Basically, irrationality of Wednesbury, procedural impropriety, illegality. These three are the principles.
officially recognized.
These three are
Correct.
pervading every
Yes.
tender.
Here, the same principle will govern this case also. The only distinction being, my lord, here the object has to be taken note of. For example, my lord, I'll give an example. Now, when somebody claims exemption, now, supposed intention of the authority to exemption is never to be considered. What is to be considered is the person or the party who claims exemption, whether he comes within the four corners of that exemption notification. Otherwise, you will not get it. And unlike in a, my lord, normal taxation statute, where in case of any ambiguity, my lord, the ambiguity is always resolved in favor of the SSE. But in case of exemption, it will be always, my lord, resolved in favor of the revenue. The idea is very simple, my lord. If an objective is sought to be achieved by any action of the government, then, my lord, whether that objective has been, achieved or not, that will be of paramount importance. The objective is, my lord, decentralized procurement. And why decentralized procurement? That is the experience which shows, my lord, that centralized procurement has not delivered the desired result. Therefore, the government, my lord, came up with their policy. Now, for a state government, that too in a field which is covered by NP7, whether they can take a contrast. In fact, rather, I would say, my lord, to respectfully submit, my lord, in the uniform judgment, this aspect, though I argued, my lord, it was not gone into. Here, my lord, lordship may like to highlight something on this aspect. My lord. Even if you have, you can have it in a manner prescribed as in 254.2 or that page 134. Or, my lord, you cannot, it cannot withstand the judicial scrutiny. That is my humble submission.
Yes, Mr. Chairman.
Oh, yes.
At one.
The lordship's kind person.
Lordship has pointed out one thing regarding eligibility criteria and the participating in tender process. What we have stated in our paragraph, Lordship. Para 8 of the repetition, Lordship.
Para 8.
What's it?
Para 8. 7967.
7967. May I read, Lordship? Though petitioner found himself eligible for participating in the said tender process, fulfilling all other criteria except minimum average annual turnover, petitioner could not participate in the said tender process because of the criteria laid down regarding minimum average annual turnover. As such, petitioner restrained from participating in the said tender process, though petitioner was interested in participating. And reply to that, Lordship, paragraph 8 has been replied. That with regard to the paragraphs made in para
Cannot
8.
otherwise reply also. Full conditions or not, it is your thing. They cannot reply.
No,
They are states.
No, they have stated.
They are states.
They are pointing out that the BIS standard certificate is necessary. There is BIS standard certificate is necessary. Material should be of BIS standard.
They are state. You are a citizen.
Lordship.
They have made a tender notice, published. They are not going to find out which trader is fulfilling one. They can examine only when you file a
Lordship.
tender.
No.
They cannot go to your
No,
Forest Lumber office and find out and make a statement and contribute a statement. That is not the.
No. Lordship has pointed out.
You should have pointed out that these are my documents except annual turnover.
No, I have stated.
That
I
is
have the
two-
qualification.
To general estate.
That general qualification. And secondly, Lordship, they have not stated that the furniture should be BIS specification. Material should be BIS specification. Material used in the making of the furniture should be of BIS standard.
See, in this case, neither the petition has made some specific thing, nor the reply. All have referred to FMP.
FMB and secondly, the
FMP extensively, which is not part of the
repetition
either repetition or
in the affidavit.
few pages of FMP are enclosed.
Now we have stated. We have stated.
So ultimately, in the Union of India, something more has come.
That is mandatory.
Neither in the, because all hours and hours have been spent on FMP. Nobody has made it part of the writ petition.
No, we have.
Reading.
No, we have annexed part of the FMP with a specific statement that we crave the leave of this court to produce the same at the time of hearing.
Okay. Anything?
And that is, Lordship, only thing is, Lordship, in the tender notice, it has been stated that the specified material should be used of BIS standard. Special material should be used of BIS standard.
Okay.
We are using that.
Let us see.
Which page? Lordship. Lordship will find page 40. Page 40. Materials, particulars. Materials, particulars, decks, bands, and brake rest. Tabletop decks, brake rest shall be made of Iman, MDF board, IS Iman or lattice. It should be made of that, which 0.5 ml all side laminated and all edges to be fitted with 2 mm thick injection molded virgin polypropylene copy minor. The deck shall be green guard and Iman and voltage organic compound. Second, project modesty panel, 18 thick board Iman, IS or lattice. The material should be of that specification. Not the Lordship, the furniture. Material is in making the furniture should be of that specification. So there is no question of Lordship, the material, the furniture should be of the ISA specification. Material is in the furniture should be of that specification.
Come to page 27.
Page 27. Lordship.
That broad box document required from seller.
Yes, Lordship.
Experience criteria, past performance,
bidder,
turnover.
Okay.
Basically, you are objective to this also, bidder turnover, certificate, requested in ATC. What is ATC?
Request ATC additional doc.
What is ATC? Because additional document 2 requested in ATC. Additional doc 3 requested in ATC. What is ATC?
Compliance of DQ specification and supporting documents.
Huh?
Annual turnover.
Okay, annual
turnover certificate.
And what is this annual turnover certificate? Requested in ATC? Requested in ATC? Buyer.
Turnover criteria. I think turnover criteria.
Think will not do.
I do not understand. I admit it.
Perhaps, however, think those will not do.
I do not know.
In a tender process.
I do not know.
Yes, Mr. Bora, what is ATC? It is your authored document. I'm asking you because this is for a specific thing in mind. Specific. View file, page 29. So, you, Mr. Gusavi, did you download the document?
Download the document.
This specification document?
Download it.
Do you have that?
Lordship, if I may point out, Lordship, I think I've got it. If your Lordship will come to page 32.
32.
Additional terms and conditions.
Yes, 32. Original.
Corrigendum,
Bid coordinator.
buyer added bid specific additional terms and condition. Here, if your Lordship will see, requested.
This is ATC perhaps.
This is ATC.
Additional terms and conditions. This could be the possibility. Not annual turnover
Additional
certificate.
transaction. That may be additional transaction.
I doubted it.
That is additional transaction.
You are Uddam.
Lordship,
Certificate holder, MSc, SC or what?
that is the certificate required for small scale industry done.
Ah. So, in case that same thing, page 27. In case any bidder is seeking exemption from experience stroke turnover criteria, the supporting document to prove his eligibility for exemption must be uploaded for evaluation by the buyer. So what is the exemption from turnover criteria? You are espousing a public cause because you do not meet the, we are not in PIL,
Not.
right? You are espousing a public cause because you do not meet the turnover criteria.
Turnover criteria.
Turnover. So, what is this exemption from turnover criteria?
Turnover criteria is minimum of 9.52 lakhs. There is no discussion regarding Lordship, the
No, there is star. That is why asterisk is there in that. In case any bidder is seeking exemption from experience stroke turnover criteria, the supporting documents to prove his eligibility for exemption must be uploaded for evaluation by the buyer. This is also there. So your whole case is structured on not meeting turnover criteria. But since you are an MSME, what is the exemption? Because we are 226,
Lordship.
right? We are not in PIL. We have to understand
From the
that the bidder's personal grievance. So you are considered, you Udyam, you have annexed perhaps. You have annexed, right?
Lordship.
Udyam, then what is there? Manufacturing. Manufacturing. And what kind of manufacture? Furniture.
Furniture. GST is restriction
So
and
furniture.
furniture.
So what is the exemption criteria? We can only see from the perspective of this Hemanta Malakar. He cannot espouse to the cause of others. Yes, anybody, please. MSME. Yes, Mr. Gautam. Tell me now. We are not into PIL.
Not
Tell me. You claim to be a
small scale industry.
small enterprise.
Lordship.
There is something, there exemption from turnover criteria.
What discount to turnover criteria depends the bolegile. Turnover criteria.
If you are under exemption,
Exemption jodi ache.
you can get the entire quantity of 31 crore.
Turnover criteria.
If you are statutorily entitled to be exempted, Mr. Goswami,
Lordship.
if you are statutorily entitled to be exempted from turnover criteria, matter ends here. We are not into PIL. There is a statute, MSME Act. Can you highlight? Nobody has argued this. We are into all this jargon, public interest, public benefit, community participation.
Only section 11.
Huh?
Only section 11 speaks about preference.
Then thereafter many notifications. Another repetition is pending regarding your notifications. Tender matter. See, Mr. Betala, if he is statutorily entitled to be exempted from the turnover criteria, if statutorily or by the government notification, he can only raise his individual grievance in 226,
Not at this.
not for public, entire public. You are not a manufacturer association, you are single manufacturer. So if you are a MSME and if you are statutorily exempted, I want to know if that is there. Nothing is there. They will consider as per your entitlement.
That is, I have stated in my paragraph that because of the, let's say, turnover criteria, I could not participate.
Right.
Turnover criteria. But they have highlighted the FMP as well as the.
Oh,
CSR.
don't go for that. You are not espousing community cause. Show me any law by challenging a tender process. You are into PIL.
No, I'm
You
not.
are trying to uplift the community participation. All these are lofty ideas. If you are challenging a tender process, you are into tender jurisprudence, not into public interest jurisprudence, right? So what is there? If you are exempted, suppose, I don't know, nobody has addressed it, just then it is individual claim. Your case will be considered. And your only case is that paragraph 8, you are not meeting annual turnover criteria. Yes, Mr. Devchuri, please. You are the man, MSME. Otherwise, 226, tender jurisdiction, one can.
It restricted to him.
Him only. So his paragraph 8 case is that he has met all the criteria except turnover criteria. His specific state.
Yes, Lordship.
This particular thing, they have said, in case any bidder is seeking exemption from experience stroke turnover criteria, supporting documents to prove his eligibility for exemption must be uploaded for evaluation by the buyer.
That has to be supplied by
What is
him.
the statute? What does say MSME and its notifications? That will not do. There are notifications from time to time.
Yes, Lordship, it is reading the section will not happen.
One is clear
Yes.
that MSME is exempted from submitting EMD. That already relaxed. I have seen. Next page, please see. Below the table, page 28, EMD exemption. Under MSC category, only manufacturer for goods and services, providers for service are eligible from exemption from EMD. Right. Traders are excluded.
Only, let's say, the security I have incurred, only the, let's say, the.
Why then?
Earnest money,
No,
earnest money, there is no question.
no, why this turnover criteria?
Turnover and criteria, there is no discount. As per MABC. Turnover, there is no benefit to the giving to the any small scale industry. Turnover criteria. Except the, let's say, the earnest money, EMD.
That is specifically mentioned here.
Is why,
There is a specific condition.
the earnest money criteria, there is exemption.
Page 30. Yes, sir.
Meeting as an-
It will be okay.
No exemption.
No exemption.
Okay, I'll make the research myself.
Let's say, I can also give lots.
No, after today, no.
No, to
If
quote
I
Mr.
find it that
As far as-
turnover criteria is exempted,
As per my information received from a client, there is no discount for
no,
turnover
okay, I am recording your state.
turnover discount. There is no.
Turnover criteria.
There is no exemption.
So So case 21 asterisk condition is misconceived. Because this document is prepared after extensive research. Condition is misconceived.
Copy of yellow. Lordship, there is, I'll take out the,
Eligibility criteria has been noted, Lordship.
I'll
Page
take out
35.
the copy and I'll furnish to the court.
That is there.
You can send it to the court master again directly.
Yes, 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 I'll do that. I'll just read out, Lordship. It's a office memorandum of 25th July 2016. Paragraph 2. Ministry of Micro, Small and Medium Enterprises Wide Policy Circular dated 10th March 2016 has clarified that all central ministries, departments, central public sector undertakings may relax condition of prior turnover and prior experience with respect of micro and small enterprises in all public procurements subject to meeting of quality and technical specifications. Subject.
So technically is that technical, desk and bands, turnover criteria is exempted.
Subject to meeting.
Technical criteria, he said it should be made up of.
I'll furnish it.
Okay, come only with that, only this thing remains. If you are exempted from turnover criteria, you are open to submit bid. You are meeting the specification criteria, and there is a policy that if a MSC bidder applies, you have a policy, central government policy, then a particular percentage of the procurement should be given to them.
Regarding purchase, Lordship, regarding purchase.
This is purchase, nothing else.
Oh, yes. Regarding purchase, they have.
This is nothing else.
Yet some percentage should be given to the small scale districts.
Yes, it is mandatorily reserved. So if it is bulk,
A percentage of it.
say 20,000 desk and bench, at least 5,000 should be reserved for,
Small scale districts.
right? You have a policy, please find out the policy. If that policy and he is entitled, then his paragraph 8 goes. In paragraph 8 goes, he is not in PIL, then he should claim exemption.
That has to be pleaded. He has to come up with that.
We can give him that, at least this court has 226 power. Even if the last date is over, that bidder is permitted, petitioner is permitted. We can exercise that power,
Yes.
right? Find out it. If you are still eligible,
I'll try to collect.
then result may go this way or that way. But if you are eligible, you are only espousing your individual cause. And if you are can claim exemption under the policy, then we can permit you. Mr. Bora will not have any objection. Mr. Betala cannot have any objection because wider participation. He cannot object also. As simple as that. Otherwise, we will close. Just for that information.
Gosh.
It is for you to make the research and
I'll give
placement.
Lordship.
We can place it on Monday only for that.
If I have some difficulty on Monday and
Why? Out of station.
some matter fixed in Kohima. I will.
Tomorrow
Tomorrow,
at 4 o'clock.
I'll try.
Done. Okay. Betala, make the, yes, Mr. Gautam.
We'll research.
If you can find out, you are eligible to bid and get all those notifications that 5% or 25% is reserved for MSc. If all these big players are there, your 25% is fixed. Have you understood my point? Okay, tomorrow. Yes, will be taken up at 3:45.
Yes. Intend to continue again. That's
Intend to come. Oh, these are this partly dictated matter on Tuesday. I was in the process of dictating 4 repetitions, right? That will be on Tuesday. No point.
obliged.